exam next week, I will remove the repeated meeting.
How much time you require?
Next week, proceed. Next week, we
That
will
counsel
remove.
for the petitioner takes 1 week time to remove the defects as pointed out by the stamp reporter. Is this matter 1 week for record? Yeah.
Problem.
Item 2.
Find it to file a better application. Legal.
Petitioner, Mr. Jagmohan Patnaik,
My name is Jyotiranjan Bey.
Mr. Jyotiranjan Behera files a memo of withdrawal of the writ petition being signed by the senior Jagmohan Patnaik seeking permission to file a better application. Memo is taken on record. The writ petition is disposed of giving liberty as prayed for. Same order in the connected room.
Item 3. Item 4.
For amendment for writ petition filing to the matter in course of the day.
You are filing it with Mr. Manoj Kumar Kandal and counsel appearing for the petitioner submits that he intends to file an interim application for amendment of the writ petition in the course of the person. That a copy of the same be handed over to the land council for the state. Matter be listed next week. Listed next week with the interim application, if any, filed in the meantime.
Item 5. Item 6.
Item 6.
Yeah. The order cancelling the lease in favor of a ex-service, ex-military person has been confirmed by the honorable member with the RDC Central Division Quarter. The Lordship, the informed order at Annex 12.
You said that one writ petition is connected to this writ petition.
Yes, as well as that.
That has come today. 30576.
Yes, my lord. That is.
Which is which item?
That is item 5.
Item
5.
Yes.
And that is not related. That is the order.
Related, that is there the question involved while the lease was granted.
No, you made a mention on that day. That is how.
Yes, the earlier order was that is prior
the order was
last order. Earlier
if
order
it is
was,
not connected, then you can place this matter there. So, what is this matter?
here, my lord, the lease was granted.
No, what is your prayer in this petition?
The prayer to pass the order cancelling the lease.
Which is that order?
That is Annex 12, page 50. Start from page 59.
Please come to that, trace it, let us see that why it has been cancelled.
The appellant has filed this appeal under section 7C of OGLS Act 1962, challenging the order dated 3/6/2022 passed by the collector and District Magistrate Moirganj in lease case number 204 of 2003 in resumption of the land leased out in favor of the appellant. The AGP is present for the state. The counsel for the petition is absent. The case was heard in detail on 6/9/2024. The appellant has challenged the order dated 3/6/2022 of the collector Moirganj in lease case number 204 of 2003 in resuming the land leased out in favor of the appellant, who is an ex-serviceman. The impugned order is based on the orders dated 29/4/2022 of the sub-collector Baripada, passed in miscase number 21 of 2022, and the order dated 23/2/2022 passed by the Tahsildar Baripada. The lease was granted to the appellant by lease case number 204 of 2003 for the purpose of agriculture and possession. For the agriculture and possession was given on 7/2/2005. Subsequently, the lessee took step to sell the land, alleging financial constraint, and when the same was refused, he approached the Honorable High Court in WPC number 25849 of 2021. The Honorable High Court directed the Sub-Registrar Baripada to examine the registrability of the suit land as per law. Then he filed inquiry. Then a field inquiry was conducted by the revenue supervisor and the revenue inspector, who reported mentioning that no documents in support of illness is produced, and his son is a Group A officer working in the government of Odisha, and financial condition of the appellant is good. Then the Tahsildar himself conducted the field visit and found that the suit land remained vacant and no sign of cultivation is traceable on it. Subsequently, he issued show cause on dated 22/12/2021 for cancellation of the lease and the resumption of the land due to violation of the terms and conditions of the lease by not using the land for cultivation purpose, and also construction of a road without permission. From the order dated 23/2/2022 of the Tahsildar in the resumption case, it is clear that the show cause reply given by the appellant has been considered in detail and not found satisfactory by the Tahsildar, giving details region wherein, as seen from the LCR. It must be mentioned that the appellant admitted during the field visit of the Tahsildar and signed in the memorandum prepared that he has not cultivated the land for the previous 15 years. Tahsildar sent the case to sub-collector Baripada, who recommended the resumption case to the collector, and the collector had ascertained that the lessee has not used the lease out land for agricultural purpose, which is lying vacant for 15 years, and has constructed in Moram Road over the plot without permission, which indicates the intention to use the land for non-agricultural purpose. Considering the detailed statement of the lessee and joint inquiry report, the Tahsildar has rightly confirmed the resumption of the said land to government khata as per the provision of under section 3B of OGL Act 1962. The council has made a pleading that he has not used the land for any other purpose, even if it was uncultivated, and hence, even if it is lying fallow, same cannot be resumed. Such a claim is not acceptable, and as per the amended provision of OGLS Act, which was allowed on the non-use of the land for the allotted, Also, as per the provision of Section 8 of Orissa Land Reform Act 1960, resumption and eviction of royalty is allowed if he makes the land unfit for agriculture, or if he fails to cultivate the land personally. In the present case, it is clear that the suit land has been leased out for cultivation, and same has not been cultivated by that land. Hence, there is no error.
What is wrong in it?
The wrong
There
manner.
are two admissions. One first admission is you have misrepresented, saying that I'll sell it, whereas your son is a class 1 officer. Second one is you have admitted that it's uncultivated. These are the two ground on the basis
No,
of which you
I have not
bring it.
admitted. That is my objection. That has not been taken into consideration. I know where I have, a lordship may call for the LCR, the lordship will get nowhere I have admitted that I am not using the same. Rather, my objection is that I was cultivating the same. It
No,
is
no.
my objection is that I have filed
The report is
the,
very
apart
clear.
from that one, what legal point is involved,
Yes.
that is where the land was allotted in the favor of the petitioner, not as per the OGLS Act. So they cannot resort to the provisions of OGLS Act.
So is the lease deed.
Lease deed, my lord, is not there, but
Then how do you say so? Have you got all these orders are here before us? In paragraph number 2, it is mentioned that one order is passed by the collector, that is dated 3/6/2022. Another order is dated 29/4/2022 by sub-collector in this case number 21 of 2022. Another order is passed on
Yes, sir.
23
What has happened, my
2022
lord?
by Tahsildar Baripada.
Yes.
Have you annexed all those orders here?
I have annexed all those.
Acha.
But in fact,
Please
the
come to the
Tahsildar, when I made an application seeking permission to sell the land, the resumption proceeding was initiated by the Tahsildar. The Tahsildar forwarded file to the sub-collector. Sub-collector sent it to the collector. Then the collector passed the order. So
No,
collector passed the order essentially
the
under
legal point which you are raising,
yes.
that suppose a land is leased out in the not under the provisions of OGLS Act.
Yes.
Then according to you, under which provision it has been given lease to you?
So it was given
If it is a Jawan lease, matter is different. If it is not a Jawan lease,
it is Jawan lease land.
then where is the document to that?
That is
Who is Jawan? Are you a Jawan?
annexure to yes, sir. Ex-serviceman, they have in the order they have
Where is that order to show that it was given on Jawan lease? And it is a Jawan lease, then there would be a certain terms and condition.
My dear lordship may turn to page 21, annexure 2.
Yeah.
The order dated 10/3/2004.
Yeah.
Where is the petition?
Rajya Sainik Bond, Orissa, Bhubaneswar, and Jilla, sorry.
Where is the petition filed by the by Sri Sudhanshu Kumar Dwivedi, son of Bhagavat Chandra Dwivedi of Baripada, for settlement of 5 acres of government land in his favor as an ex-serviceman of the Indian Air Force. So it is a Jawan lease.
Wait, what happened then?
Then by virtue of that order, manner subsequently it was leased out in his favor.
What is the terms and condition? So this order is the next page, sir.
Your lordship may turn to page 25.
Just a minute.
That's the continuation order.
The 10/5/24, 2004, the second subparagraph indicates first subparagraph. On verification of the lease application, it is found that it is an ex-serviceman, the applicant is an ex-serviceman earlier working in Indian Air Force. He has submitted the certificates received from Rajya Sainik Bhubaneswar and Jilla, so and so. The attested Xerox copy is okay. Then what happened? RI has submitted in inquiry report that he has stated that the applicants want so and the members purchase so and so stated that no agricultural land in his name nor any family has also been submitted. The affidavit stating that he has no acre. Also, you have one stipulated within the land and there is no Yes, mentioned no.
The relevant person settling the land in favor of the petitioner will also get that.
Just a minute.
Right.
Whether you mean to say that the authority has no power to initiate a resumption proceeding?
Under the
Page 30.
OJLS Act,
Page
because
34.
it since it was
30. Page 30. Middle part. This was granted to you by lease number four of this court. This lease was also granted as per the term visit to the undersigned above and schedule following observations when found in violation of terms and conditions of the lease.
the findings that the land was never utilized for the purpose for which it has been leased out is not correct, because in my so cause you'll also get at page 37, my specific case is that I was using the same purpose, but it is stopped since 2018.
Where is that?
That is page 37. No, my so cause reply to the so cause notice, annexure 7,
35.
page 37.
Which allegation?
Allegation 2.
Hmm.
The so cause submitted under the allegation number 1 will make good the reply against the allegation under item number 2. It is to be reiterated that the land was under activates from the year 2005 to 2018 for about 14 years, and due to my health problem, the same has been discontinued at present, and I am under treatment, and the cultivation activities will be again started shortly after my recovery. That but they have stated that that has not been taken into consideration neither by the
The land in Jawan is state council.
Lordship, I would request your Lordship to kindly have a glance at.
I'm asking you a plain and simple question.
Yes, Your Lordship.
What is the provision that a land can be given to a person under Jawan lease? Which is the provision?
Lordship, that I have to look into. Your Lordship.
Don't come to this court unprepared. Both of you get ready. We'll take up this matter day after tomorrow.
But in your where you see it.
In
And
the
if you are
reply-
taking a specific plea, you must tell us
Yes, yes.
which is the provision.
Page 37, madam.
Yes,
Page 37.
where you see.
Just I read out this, my reply.
This point you have not taken. That's not good.
The allegation number two.
Get prepared. This writ petition has been filed by the petitioner.
And it may section 3 is clearly stated. Ek service में your lordship may see who can be in which paper the land can be settled. That is under OGLS under section 3. The lordship ex-servicemen or members of the armed forces of the union if they belong to the village in which the land is situated.
Jawan lease, there is a separate.
That is under lease.
Your lordship may see the section.
Oh, we know that can be granted, but for Jawan lease, there is a specific.
But this has
procedure
been granted.
There are also decision of
this.
this court that how Jawan lease is to be granted and we can resume it. There are decisions.
I will bring it to you. Lordship, call it till day after tomorrow.
Section 3, subsection C. Odisha government land settlement.
The petitioner, Sudhanshu Kumar Dwivedi, has filed this writ petition
Subsequently C.
with a prayer
OGLS.
to set aside the order dated 4/10/2024 passed by the Divisional Commission of Central Division Pasak in OGLS Appeal number 2 of 2022. In dismissing and thereby confirming the order dated 3/6/2022 passed by the Collector and District Magistrate Moradganj in lease case number 204 of 2003 in resumption of the land leased out in favor of the petitioner. From the impugned order, it reveals that the Collector and District Magistrate Moradganj passed the order dated passed the aforesaid order dated 3/6/2022 basing on the order dated 29/4/2022 of the Sub-Collector Baripada passed in Miss case number 21 of 2022 and order dated 23/2/2022 passed by the Tahsildar Baripada. All these as annexures.
Yes, yes.
The Land Council for the petitioner submitted that all such orders are annexed to the writ petition
9, 10, and 11.
as annexure 9, 10, and 11. He has raised a legal point that the petitioner got the lease of the land as he belonged to, as he was a ex-serviceman of Indian Air Force. And since it was a Jawan lease, the provision mentioned as available, those provisions as available in the UGLS Act are not applicable for resumption of such land. When this court put a pertinent question to the Land and Council for the petitioner as well as Land and Council for the state, that if a land is given to a particular person as Jawan lease, what are the procedure available for grant of such lease and what are the resumption of such land if the land is not utilized for the purpose for which it is leased out. Both the Land and Council submit that the matter may be taken up day after tomorrow. Put up this matter on 23rd of April 2025.
Lordship, kindly submit one line.
Get ready, fully ready. Don't give half a prepared answer. With citation, you come ready.
Yes, sir.
Go through each brief minutely, take note of the points raised in the writ petition. And if you have anything to say, also take note of that. With citations, come prepared in every case. Yes.
Item 7.
My leaders. Item number 7, 8, 9, and 10. On behalf of Mr. Mishra, I pledge for 2 weeks.
2 weeks time. There is no interim order.
No. Okay, my counsel.
Yes or no?
Madam?
No interim order is there.
No, it's not.
What is your good name?
It's Saracen.
Mr. S.R. Acharya, Land Council appearing, or Mr. Gopund Mishra, advocate, submits that the matter may be taken up after
2 weeks.
2 weeks. It is this matter. Some petition for me.
Item 11.
Password. Okay.
Item 12. Item 13.
Petition was directed to file amendment petition.
When this type of thing is mentioned, there should be a specific schedule.
Yes, sir.
Schedule of amendment, and the prayer should be to allow the schedule of amendment.
Yes, sir.
Schedule in the cost title, schedule in the averment, schedule of prayer portion. It is to be mentioned like this. You have not mentioned that schedule of amendment.
Only the
in the
amendment
prayer
section
portion.
overflow has to mention that is.
And if you have left out any documents to be mentioned in paragraph 8, 10, 11 or 10, 12,
Unnecessary should be mentioned.
take those grounds and file a fresh petition. So that otherwise you are again to require to amend it. Right? You say that some of the documents are still to be filed and those are to be annexed as annexure. So that is how, like on the IA numbers one, so this is an application for the land council for the petition or 6 permissions to withdraw this interim application for amendment and to file a better one. The interim application is disposed of as not received.
The consolidated petition I filed there. That may be there.
And though a consolidated writ petition has been filed, this land council for the petitioner also does not want to press the same accordingly.
That in consolidated petition that is mentioned. Need not be that amendment petition will be filed, but no giving mentioning the schedule and the annexures. The consolidated
The consolidated writ petition.
Yes, I have mentioned.
10, 11 songs.
Yes, yes.
The consolidated writ petition উপরে কিছু order লিখি কিছু order লিখি না খালি interim application টা ইয়ে করে IN number যেটা 5439 of 24 আছে है ना সেটাকে not press করবে yes next আপনি যে ফাইল the match when you file the land council Mr. Patnaik submit that he will file the interim application for amendment by tomorrow. Is this matter next week with the interim application for amendment even filed in the meantime? Yes.
Item 14.
On behalf I have already served copy, my lord. I have received it. Now, I received, I want to file the objection to the intervention objection.
You are for the
Petitioner of Mr. Arjun Karan Behra on behalf of Arjun Karan.
You are for the petitioner. Who are you?
I am for the intervener, my lord. I have already served copy to Mr. Behra.
Or you are Mr. D.K. Sahoo. Okay, you have received the copy.
I want to
and a copy has also been served on the land council for the
yes, my lord. No,
intervention application which is 6325 of 25.
That copy is not. I have served in the office of the advocate general, not that.
Acha. Dilip Kumar Sahu, na? Dilip Kumar Sahu. Mr. Dilip Kumar Sahu. IN number eta likhi debe. IN number 6325 of 25. There is an application for intervention. Mr. Dilip Kumar Sahu, Land Council, who has filed the intervention application, submits that he has already served a copy of such application on the Land Council for the petitioner, and which is not disputed, petitioners, which is not disputed for the petitioner submits. Stop. However, though he submits that the intervention application has been also served in the AG office, the Land Council for the state submits that the said application has not been tagged to the file, and the matter may be taken up next week to verify the same. As prayed for, release this matter next week. Yes.
Item 15.
The petitioner challenging the order passed by the Illinois Central Tribunal Patar, the case 164 years, that is 2023 years. Operative part of the order, page 171, 7 years. The main plans of contention of the applicant.
You are the applicant in the. What was your prayer in the before the Central Administrative Tribunal?
There is a passing of the. There is a demonstration which was passed on 1/10/2020 without giving any notice or any giving the That is the proceedings under eviction of proceeding at sector 7 Lordship. That is because it is after 3 years, because he has transferred from Bhadrak that 2014 Lordship. It was equivalent to 2010, 20 Lordship. Fixed actually. As per the rules, that is 2 years. And that type of Lordship, the amendment should be assessed by the Eviction Proceedings Act. Lordship, what we have written in page 171, paragraph 7 Lordship. The main plan for contention of the applicant counsel is that the respondent only declared the possession of the quarters as unauthorized only in 2020. That is from the 2014 transferred to Hon'Ble, Bhadrak to Hon'Ble. And no eviction proceeding was done earlier. Therefore, they could not claim damage rent from 2000. However, there is a
suppose you are a government servant and you are posted at place X and you are allotted a quarter. So obviously house rent would not be paid to you because you are occupying. Now you are transferred to another place and you retain that quarter.
Yes, sir.
Right?
Yes.
So and in that place also.
No, I have not given the quarter. Though I have
you get the house rent.
Yes, sir, they have not paid the house rent.
No. Suppose somebody, have you informed the authority?
Yes, sir.
Have you surrendered that house to the?
Not
then
because
what is the procedure? That suppose somebody is posted today at Qatar and is transferred to, let us say, Baripada, and he is having a government house. So is it not supposed to surrender unless you surrender it? It cannot be handed over to
after 6 months, Lordship, because of the ground. My children are living at that point of time.
So you are enjoying that property. Your children are studying here. So you are enjoying that property.
They took the
and also took the house rent there at Baripada.
No, Hon'Ble.
No,
I have not a house rent university. That has not been their case.
Where is your case to that effect?
Your Lordship, paragraph 8.
Please come to the reasoning given well.
Yes, sir.
Paragraph 8, page 171.
However, the provision of the master circular above states that the normal period of retention after transfer is 2 months, and thereafter, on request by the employee, the same can be extended for further period of 6 months by a competent authority. No document has been filed by the applicant to show that he has made an application for extension of retention of quarter, and whether and permission to that effect has been given.
Just read further.
Read further.
Further,
as per clause 11.
As per clause 11 of the master circular on completion of the permission period, the allotment of quarters shall automatically be deemed to have been terminated, and the retention of the quarters will be treated as unauthorized in the employee shall be realized from him. There is no provision for declaration for treating the quarters as unauthorized. When the allotment is terminated automatically, thereafter retention without permission is unauthorized, and damage rent has to be paid by the applicant. In the decision cited by the applicants, there is applicants without discussing the that is not applicable. Dr. Lordship, kindly turn to page. What happened, Lordship? I have transferred to the Bhadrak to Hon'Ble, page 34, Lordship.
No, this master circular, whether it is applicable to you or not.
We have not that.
Where is the copy of that master circular?
That is not true.
Then?
That is not there.
You are arguing
Neither
the central administrative points must have been raised also in the counter affidavit.
No counter has been
no counter affidavit filed.
Counter filed, but they have not.
In the counter, they have not taken this down. Let us see.
Lordship, kindly see, no documents. So far as no documents, Lordship. After transfer to Hon'Ble, page 34.
After expiry of 6 months, have you got any permission for continuation?
Why Lordship, I will draw attention that is page 34.
No. Even if you have, let us say you will apply for that.
Yes,
whether it is for the authority to grant you extension beyond 6 months.
Beyond 6 months, this Lordship can grant you.
It's all right. Merely applying is not automatic.
Yes,
unless it is a specific order is passed
yes,
in your favor.
Yes, Lordship.
And it is after 6 months you have to surrender.
Yes, Lord.
You come to page number 67 of the counter affidavit.
Yes, Lord.
Which is internal page is 6 and
67, Lord.
67 ଯୋଉଠି ଲେଖା ହେଇଛି permanent
Yes, Lord.
ପଢନ୍ତୁ ପଢନ୍ତୁ
It is the 99 of 2020, RB guideline 99 of 2020. It is not the master circular, that is the 59 also.
you mean to say that this is not applicable?
I have also enforced that documents 99 RB 99 of 2020 also. Because that is stated that in 1.3 also, from 1.3, that is the eviction proceeding should have been taken there also. And so that document.
Where is that document?
99 for 2020 also. Or master circular.
ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା eviction proceeding ହବ ତାପରେ ଯାଇକିନି ହେଲେ
Yes,
କୋର୍ଟ
Lord.
ରିଏଲାଇଜ କରିପାରିବେ ନହେଲେ କରିପାରିବେନି where is that provision?
I also saw the Lordship page
ଫାଇଲ କରନ୍ତୁ ଡକ୍ୟୁମେଣ୍ଟ ଟା ଫାଇଲ କରନ୍ତୁ
114 Lordship.
140 ରେ ଅଛି
14 days.
114.
Yes, sir.
Let us see.
RB number 99 of 2020. That is that 1A Roman 3.
Just a minute. This is dated 24/11/2020.
Yes, sir.
When your this transfer took place.
14.
So
There is
this was not in force then. This came into force in 24/11/2020.
Yes, Lordship. The extension of revenue quarter and transfer of deputation. The instructions contain board's letter of event number dated 1/6/2001, RB number 1/1/2001. It is clarification.
Yeah.
Given the permissibility, will be allowed on any ground whatsoever. Therefore, no request on representation on this score shall be entertained for all occupations beyond.
No, it says this one which you are reading, 24/11/2020. It says that the instruction of that date that have been reviewed by the Ministry of Railways and decided to partially modify, and this is the how they have modified it. So this came into force on 24/11/2020. Prior to that, the what was the instruction?
Instruction is
and you will be guided by that instruction, not the decision which came into, because your this cause of action took place in 2014, not in 2020. So 2014 no kon thila seteବେଳେ?
At that point of time, rule provides, and also judgment law provides, CS limitation as well as the applicable.
ଦେଖୁନାହାନ୍ତି ପ୍ରୋଭିଜନ କଣ ମୌଖିକ ଆପଣ କହିବେ ନା କଣ କୋଉ ରୁଲ ପ୍ରୋଭାଇଡ କରୁଛି କଣ ପ୍ରୋଭାଇଡ କରୁଛି ଦେଖାନ୍ତୁ ଆପଣ ଯେ ସେତେବେଳେ ଥିଲା ଯେ ପର୍ଯ୍ୟନ୍ତ ଏଭିକ୍ସନ ନ ହେଇଥିବ ସେ ପର୍ଯ୍ୟନ୍ତ ଆପଣଙ୍କୁ ଟଙ୍କା ସେମାନେ ରିଏଲାଇଜ କରିପାରିବେ ନାହିଁ.
No, even if you retain the house, you have to pay the special rental, double the lease amount, whatever.
Yes, sir.
You have to pay the.
Yes, sir. But what if
it's not free of cost.
Yes, sir, not free of cost.
Then
you lordship, why draw your lordship attention? Tribunal held in law that no documents has been filed in us. Why I am drawing that there is 34, 30, 36 and 37. Only 3 pages. 34 lordship. Dated 19/7/2016. When I joined, paid for before the honorable. So last line. So I may please be alerted to the above said quarter noted down the subject in favor of me, which act of the kindness actually before the honorable lordship. They given the notice lordship page 36 and 26/4/2017. Lordship. Look and 26/4/2017. 26/7. Call for expansion in connection with unauthorized retention of railway quarters at Bhadrak. When I joined the lordship, the staff who are retaining quarters beyond the policy period.
37.
36, then 37. 36 so cause has been given me also. Thereafter I give the reply 26/4/2020 to 8/4/2017. Page 37. I therefore beseech you fervently to kindly consider the case sympathetic to and exonerate me the above charges with grant permission for retention of railway quarters order from 5/12/2020 to the allotment of a railway quarter in favor of me at Onur. The last part. Yes. I therefore
beseech you.
Fervently to kindly consider the case sympathetically and exonerate me the above charges with grant permission for retention of railway quarters. Substances for the period from 5/12/2014 till allotment of a railway quarter in favor of me at Onur. In accordance with substances which act of a financial.
Where is the order passed on this?
No order has been passed.
That's what. Then the permission is not granted.
They have
You may have a very good retention of the quarter, but if the permission is not granted, what to do?
That has been taken note of by this tribunal or the department.
See, the rule says that may be granted. Permission may be granted. Expression is may be granted. If you may have a good ground, but the authority has not granted, so therefore you have to pay. As simple as that.
Is there any deeming provision that if you're on your representation,
they have not acted upon.
No,
they have not acted upon. No answer.
That will be deemed that permission.
I thought that because they issued the thereafter there is no communication in the order, Your Lordship.
So therefore there is no permission granted.
27 to 2020, Your Lordship.
Maybe, but it's deemed rejection rather. Not passing the order on your representation is deemed rejection, not otherwise, which you have taken.
Your Lordship.
And you have to pay it.
Lordship,
you have retained the quarter, you use that quarter, your children and family members are staying in the quarter and you will not pay rent, a single paisa.
And I have not also paid
and the person who has joined in your place, he might have suffered for your retention of the quarter.
They took the stand by the tribunal that no documents have been given, Your Lordship. I read the documents, Your Lordship. And Your Lordship, Your Lordship, kindly see page, Your Lordship, that is.
Where have you said that you have not got house rent in the transport place?
Yes, Your Lordship.
You will get it. You claim there. You get it. And you adjust that money here.
Have you taken any ground?
Yes, sir. In Bhadrak, page 45.
You are entitled to house rent there.
Yes, sir.
You will get it. You claim it.
Because
that's a separate thing. Claim it. Whatever you get, you pay here.
Because I have occupied before to Bhadrak.
It's not the issue.
No, that is not.
You claim it.
Your Lordship, High Lordship. Page 45. 45, 46, 47. In Bhadrak grade. That is the rent receipt.
What we are saying that even if you are not, if you are entitled to a house rent and the authority has not given you the house rent, you can claim for it and also pay that amount here.
Here, just
retaining the quarter here. But
because from the Lordship,
and particularly when no ground has been taken in your.
I have taken the ground.
Where have you stated? In the original application,
yes, sir.
Where have you stated that you have? Which paragraph?
Let's see. Paragraph 4.12.
What is the answer, reply to this paragraph 4.4?
They have taken the Lordship. Simply says that appeals representation detailed 19/7/2016 for allotment of quarters upon who was not considered as he was not eligible at that point of time, but that does not confer increased right on the applicant to retain quarter.
Read out the other.
71.
पढ़ो तापर
The
paragraph.
applicant's representation was dated 19/7/2016 under Annex 2 for allotment of quarters at Hon'Ble was not considered as he was not eligible at that point of time, but that does not confer individual rights on the applicant to retain quarters at Bhadrak. As he did not vacate the railway quarter at Bhadrak, explanation was involved for unauthorized retention by letter 26/4/2017 under Annex 3, and it is once again reiterated that representation dated 28/4/2017 under Annex 4 has not been received. As it has been created for the purpose of this case, which is highly unfair and amounts to frequency the courts of justice in southern such. With regard to the deduction of HRA and non-payment HRA to the applicant, it is humbly submitted that since the applicant did not vacate the said quarter and Bhadrak, despite being asked to do so by letter of 17/11/2014 under Annex 1, HRA has been deducted from the salary of the applicant every month, but that does not absorb the applicant of his primary responsibility to vacate the quarters and Bhadrak, nor does it confer right on the applicant to act as irresponsible. The assertion that the applicant has requested for allotment of quarter at Hon'Ble time and again is false, except one request dated 19/7/2016. No other request has been made.
Who is appearing for that? Mr. Pari,
Yes, we are appearing, ma'am.
have you received this writ petition?
Yes, we have received the writ petition.
Oh, please come to this paragraph, page number 71, paragraph 5.
Yes, ma'am.
Come to the second sub paragraph.
Second, sorry. This serial number 6.
Page 71, that is internal page number 10 of your counter affidavit which has been filed.
Second,
Before this
as he did not vacate the railway quarter.
No, that is the paragraph. So,
With regard to the deduction of the HR and the non-payment of HRA.
yes.
And he humbly submitted that since the applicant did not vacate the quarter at Bhadrak, despite being asked to such and such. Annex 1, HRA has been deducted from the salary of the
applicant. HRA से period रे आपण deduct कर दी चालले. तो टंकाटा तो पाइले पुणी ताटू काई एक्स्ट्रा मागुचंदी ये जो टंकाटा डिमांड करूचंदी. HRA जदि डिडक्ट न करि थांते आपण क्लेम करथांते जे बाकी टंका दियो हमको से जो घरटा रिटेन करी रखिलो जो प्रथम ये रे.
Let's make come to page 83. 80 annexure R/4. Again, that is Railway Board letter dated 24/11/2020. It's clause 3. Beyond the permissible limits, however, no further extension will be allowed to on any ground.
Mr. Pari, please see the notification dated 24/11/2020. This transfer took place in 2014. So at that point of time, this was not in force. The another 16/2001 that is mentioned there in that very letter, that was in force then, and that was
the very next page, let's see page internal page 2, chronic page 84. The first paragraph itself, that action should be taken at the cancellation of the allotment. Declare the occupation and authorize and initiate eviction proceeding, charging the damage rent for the overstay.
No, he is harping on that also. He is saying that no eviction proceeding has been initiated, then why I will pay the rent, that rent. But the question is that should not be able to him, because this came into force in 24/11/2020. We are asking you that if you are deducting the house rent, even when the no quarter has been allotted in the new place of posting, then how you are again raising demand for the entire period for retaining the house at the first place?
That instruction I did, my lord. Let's make keep it some other day. I'll take the instruction.
Damage money point.
Listed for first time.
Wages, what is the rate? It is double the HRA, or how have you calculated this figure? 9 lakhs.
My lord, in that part I didn't have instruction listed first
Or
time.
you take instruction level. This writ petition has been filed by the petitioner Subhash Chandra Das, challenging the order dated 28/8/2023 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number 476 of 2020. It appears that the petitioner filed the aforesaid way challenging the order dated 1/10/2020 passed by AY10 टा किए पास करथिले अनेश्वर AY10 आपनकर page 48 that is okay.
Senior personal officer on behalf of senior personal, assistant personal officer pass there.
Opposite party number 3. Opposite party number 3. Directing the damage rent of rupees 9,04,564 from the salary of the applicant for the period from 6/12/2014 to 36/2020 as unjust, illegal, and arbitrary,
96 monthly installment.
with a further direction to the opposite parties to allow the petitioner to retain the quarter at Bhadrak with which is deducted from salary till pandemic COVID-19 is over. The Learning Tribunal in the operative paragraph has been having taken note of clause 11 of the master circular has held that the normal period of retention after retention of the quarter after transfer is 2 months. And on the request by the employee, the same can be retained for further period by the competent authority. However, the petitioner has failed to show that any such application for extension of retention of quarter has been made or any permission to that effect has been granted. The Learning Tribunal has been pleased to further object in view of the aforesaid clause 11 of the master circular, the retention of the quarter would be treated as unauthorized. And when the allotment is terminated automatically, thereafter retention without permission from the competent authority is unauthorized and damage rent by the applicant. The Land Counsel for the petitioner submitted that in the new place of posting, that is at Puri Bhadrak, na? That is at Angul. The petitioner was not allotted any quarter accommodation in spite of his request time and again. And there was normal deduction of the house rent, bracket HR, from his salary. And he was never getting any house rent allowance. And the petitioner also requested for the allotment of the quarter at on good and submitted the representation. The Land Council further argued that ସେ ଯୋଉଟା ଦେଖଉଥିଲେ 2000 କୋଉଟା ସେଟା କୋଉ ପେଜରେ
84.
Page 83, last page.
Submitted that when the cause of action arose, the
ସୌଭାଗ୍ୟ କରୁଛୁ ବାରମ୍ବାର ଅକ୍ଷୟ କି ଗୋଟେ କରୁଛୁ
instruction dated 24/11/2020 was not in force regarding retention of railway quarter on transfer deputation of retirement, which provides for of allotment and declaration of the occupation as unauthorized and to initiate eviction proceeding, charging damage rent for the overstay. It further submits that in the case of the petitioner, no such eviction proceeding has even been initiated, and therefore, as per the this is circular, na? As per the guideline dated 24/11/2020, the petitioner should not have been asked to pay damage rent, should not have been charged damage rent for retaining the quarter at Bhadrak, particularly when he was not paid any house rent allowance at on good, and rather the there was normal deduction of house rent from his salary. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. The Land Counsel for the Union of India, Mr. Parhi, the Land Solicitor General, accept notice on behalf of the opposite parties number 1 to 5. Extra copies of the writ petition be served on the Land Council. No notice need be issued to the opposite party number 6. Be placed after 4 weeks. Counter affidavit, if any, be filed in the meantime.
Item 16.
That matter, let's see, challenging the rejection of my application under section 20 the land acquisition.
Have you filed the judgment dated 10 to 2023 passed by the Reliance Senior Civil Judge Nuapada in LAR case number so and so? You took time on that day.
Yes.
And against an order under section 28A of the Land Acquisition Act that has been rejected.
Yes.
So we also asked him that whether any alternative remedy is there or not to challenge the said order.
In this regard, last 15 on the charge same matter that your lordship disposed of the matter.
Contact with the
Seven numbers of rate application.
No, why it was rejected?
On the ground that the estimate has already been submitted, but the sanction has not offered.
Let us see that rejection order.
Yes, sir. And on page 25, annex 5, last paragraph, regards.
That the estimate on this one so filed by has been submitted for kind sanction of this one so. The same has not been sanctioned till date. Since the sanction is record, has not been recorded. The petition Asha. So what is the change? Now the sanction has been received.
Annexure 6 euros.
Annexure 6.
And on page 27.
Oh. A case rate.
Same.
LAR case number
183 of 2000.
183. তাহলে এই অর্ডার অ্যাপ্লিকেবল হয়েছে আমি কাহিনী করছিল না সেই যে যে 28 ଆପ୍ଲିକେସନ ଫାଇଲ କରିବାର ପିରିୟଡ ହଉଛି 3 ମାସ ତେଣୁ ଯଦି fresh application file karo because now the sanction has already been given by the government कि अभी actually that would be time back ତେଣୁ ସେଇଟାକୁ set aside କରିକି ଆମେ କହିଥିଲୁ ଯେ ହଁ ତ same order is to be passed ତ ଏଇ ଖାଲି order ଟାକୁ change କରିବେ ନା same ଅଛି order date
same lordship patina
ନା
Annexes are different.
You in that case you challenge the order dated 4/4/24. एवढा सब करेक्शन दियो जोड़ा को ऐसा दे दियो एक गोल बुलेगी नहीं करेक्शन करते हैं रिट पिटिशन नंबर गोल बुले कर दियो
Annexure 5 your lordship may kindly glance that is the address to office of the advocate.
No, Annexure 6 here.
Annexure 6 the payment has been given by the government. Already sanction has been accorded by the government.
हाँ नहीं यही कारण पे ही तो हितला बोलते when we ask that you take instruction in that content you find that in the submission of compliance report.
One thing I may address your lordship is that previous order 15 for the similar your lordship I observe the annexure 5 set aside the order annexure 5 that is that not required to be set aside.
No.
That is the address to the office of the advocate general about the correspondence.
We will say that अगर order टा नहीं से order टा
the page para 6 previous order 15.4 is a similar matter. 9607. The copy has been provided to me. Similar. Para 6. Considering submission made by the learning council by the state parties, taking into account the ground for which the petitioner state of the earlier act.
So where is that order, learning council?
My
This is, he is right that this is, of course, we mentioned there, but where is that rejection order?
And
Right order देखना दिए, but advocate general को instruction थिला बड़ा.
advocate ସେଇ କପିଟାକୁ ଆମକୁ ଯେତେବେଳେ ପ୍ରୋଭାଇଡ କଲେ ଯେତେବେଳେ କଣ୍ଟେମ୍ପ୍ଟ ଆପ୍ଲିକେସନ ଡ୍ରପ୍ ହେଲା ଆମକୁ ଦେଇଥିଲେ କୋର୍ଟରେ ଏଇ ଅର୍ଡରଟା କଣ୍ଟେମ୍ପ୍ଟ ଫାଇଲ ହେଇଥିଲା ରିଟ୍ ଆପ୍ଲିକେସନ ଅର୍ଡର ହେଇଥିଲା କଣ୍ଟେମ୍ପ୍ଟ ଫାଇଲ କଣ୍ଟେମ୍ପ୍ଟ ଡ୍ରପ୍ ହେଲା ଏଇ ଅର୍ଡରଟା ଆମକୁ ପ୍ରୋଭାଇଡ କରିଥିଲେ the 28 application has been rejected last paragraph.
On the ground, LAR case ର order ଟା କାହିଁ ଆପଣଙ୍କର ନାହିଁ?
Data annexed.
ବୋଲେ
ସେ ଅର୍ଡରଟା କଣ ଆଣନ୍ତୁ
ଆଣିବା ପାଇଁ
ସେ ଅର୍ଡର ନଥିଲେ କେମିତି ହେବ?
ଯୋଉ order ଟାକୁ ଆମେ set aside କରି ଆପଣ permission ଦବୁ ସେ order ହିଁ ନାହିଁ ଏଠି.
ଏଇ annexure 5 your lordship running page 25.
No. On that day, somebody has not pointed out that say, all right, now he is pointing out that this is a communication from the Advocate General Office, so it is not that order itself. So, करेगा से order टा जो pass करता है.
Communication lordship running page 26 last
That is a sanction accorded.
running page 26 your lordship communication there.
The London Council for the petitioner seeks to file the certified copy of the judgment and order dated 10/2/2023 passed by the London Senior Civil Judge Noapada in LAR case number 183 of 2020, 2010, 183 of 2010. है ना? Stop केबे रखिए अपन? Put of this matter after summer vacation.
Your lordship 2 weeks.
So 2 weeks ago summer vacation was that? Yes, next.
Item 17.
Along with perseverance.
Please, your lordship. Lordship, on the last occasion, lordships have directed to put on record the orders of read petition 8338 of 25. Order dated 25th March 2025. I've already filed it. Lordships are directed to file the order dated 25th March 25, passed in read petition 8338 of 25.
No, we are not getting any such order. The only one order has been passed, that is on 10/5. That is order number 1. There nothing has been mentioned. Only mentioned that you are seeking for an adjournment with this matter on 16/4/25. That is the order. So, what is the prayer in this writ petition?
Lordship, this is for the payment of compensation.
And initiate land acquisition proceeding. then D ରେ କହୁଛନ୍ତି directing the opposite party to compensate the immediately, so and so. Okay. So basically these are your prayer with interest, of course, you are.
Prayer to declare ultra virus of the gazette.
That is in respect.
ସେ ବର୍ତ୍ତମାନ ହଉଛି ଯେ ଆପଣଙ୍କର ଯୋଉ କେତେ ଜଣ ଏଥିରେ ପିଟିସନର ଅଛନ୍ତି?
There are three petitioners.
So according to you, their land has been utilized for the construction of that river embankment.
No, Your Lordship, in this case, there is major district road 77 at Puspangi village in Dampada Tahsil of Cuttack district.
Where have you stated that your land, which land has utilized
That's
for
para
what?
8 of the petition, page
Paragraph
9.
number 8, just a minute.
मिला
कलेक्टर इनिशिएट करियो बोली जो डेटा कोड पाइले
आज्ञा सेक्शन 3 रूल 4 सब क्लॉज 1
3
only the collector
Yes,
deregulation power vested with the collector
section 3
your lordship may kindly turn to
Hmm.
deregulation power has been vested with the collector not below a rank of collector
no 3
Tahsildar cannot initiate a deregulation proceeding
no 3 रे तो कहूची power to de-reserve the land
आज्ञा देला कलेक्टर करिवे
हां कलेक्टर करियो
आज्ञा रूल 4 1 देखंतु से भी कलेक्टर करिवे आज्ञा रूल 4 1 से भी हला कलेक्टर voucher may be de-reserved by any officer not below the rank of collector so de-reserve power is vested with the collector alone.
So you mean to say that lease miscase, if any, that is to be instituted by the collector, and he may authorize also the tahsildar to invite objection.
Can it be? It is contrary to the statutory provision, Miller. Lease cannot be initiated when the land is a communal land. Once the land is brought to land, my lord, then only a lease case can be initiated. Here, the Tahsildar is acting just converse to the rule and acting.
No, the final order is required to be passed by the collector under 3A, but the initiation can be done at the.
My lord, where is that?
The otherwise also is not there.
My
Where the act or rule says that it has to be initiated by the collector.
My lord, the
What
act
does it
says,
say?
my lord, the act says
If it is silent, then the collector can take assistance from the officer who is
My
the
lord,
tester.
yes,
Contingency.
What is wrong with
That's
that's what precisely the rule is.
the rules
that
5
is precisely my contention before my
that
lord.
is the rules 5 make a glance.
5
My
I've
lord,
seen.
that is
5
Settlement of government land.
5 I've seen.
settlement is different. It is not a government land.
Only lease basis. Purpose of lease also manner of settlement is the modus operandi.
My lord, this
prescribed under
rule
statute.
5 is regarding
Be
government
it a
land.
lease miscase or any other miscase.
Final order is required to be made by the collector. That's
Oh.
right, under act. But the procedure.
My lord, when the rule says, my lord, that the collector is authorized for
Manner
dereservation.
is all applications for settlement of government land and irrespective of purpose of lease or
This is
extent
not a
of
government
area
land.
involved either in rural or urban areas shall be filed before the Tahsildar having
My lord,
jurisdiction
my lord, it
over
is
the
not a
area which
government
the
land.
land
Your
is
lordship may
located.
kindly see the definition of
So once
communal land. The
limited,
communal land and government
by the
land are two
collector, then
different things.
No,
rules.
he is raising a valid point whether a land which has been recorded as Rakhita, a communal land, a communal land ପାଇଁ a de-reservation process initiate ହେଇପାରିବ କି at all?
Hey, that here is there power for de-reservation of land. The enactment has been made power to de-reservation of land of Gochara. Unless the Gochara without de-reservation cannot be. So much Tahsildar on lease on other prescribed manner.
My lord, your lordship may see communal land definition. Your lordship will get it in the Odisha, the Act 1 of 1948.
Communal land definition.
Yes, my lord. The Odisha Communal Forest and Private Lands Provision of Alienation Act. Your lordship may kindly see section 2, subsection A, communal land has been defined.
The ground
That
agent
is also the
ଏମିତି ଆପଣ ଖାଲି argument କରୁଛନ୍ତି.
ଆଜ୍ଞା
ground ନେଇଛନ୍ତି ତ repetition
ଆଜ୍ଞା 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 ମୁଁ ସାର୍
ସେଟା annex କଲେନି ସେ ବହି କୋଉଠି ଆସିବ ଆଜ୍ଞା ସାଙ୍ଗେ ସାଙ୍ଗେ
the books is with your lordship, my lord.
ଆପଣ associate କହିଲେନି ତାର ଗୋଟେ କପି ନେଇକି ଆସିବା ପାଇଁ.
My associate is there, my lord. And the same, your lordship may also kindly turn to the definition in the government OGLS Act also.
ଆପଣ କଟକରେ ଅଛନ୍ତି ନା ବାହାରେ ଅଛନ୍ତି?
Sir, I will present your before within 15 minutes.
କାଲି ଅଛନ୍ତି?
ଆଜ୍ଞା
କାଲି ଆସନ୍ତୁ ଏଠି କୋର୍ଟରେ ଆର୍ଗୁମେଣ୍ଟ.
sir.
ହେଲା କାଲିକି ରଖୁଛନ୍ତି.
ଆଜ୍ଞା
of this matter tomorrow. Yeah, next. Yes, you.
Thank you.
Compensation extra amount, though the award was passed on 6/11/2018, that is under annexation of 2 minor. And after the letter issued by the office by number 2 to the office by number 3 minor, the amount was credited in the bank. But the bank refused that no amount has been credited in the bank minor. And the present petition was finally returned before the office party number 2.
Just a minute. Come to your representation, annexure 3.
Yes, ma'am.
This compensation amount has been credited according to that letter.
Yes, ma'am.
With the 8
Uh, for your land was acquired or what?
Yes, ma'am.
Okay.
The account number is your account number. Credited in my account.
Yes, ma'am.
So where is the document that you got the information notice? Right?
Notice.
8 and 9 the bank, the bank instruction, they have already been credited in that account. See, I mixed up 3 page 11. So the bank saying that not be credited.
Allahabad Bank.
Kannada Bank and ICC Bank. And also in the annexure number 1, my lord, and the office bank also stated they verify to verify that is the bank to verify, but they will also not sure whether that amount will be credited or not.
कि आपको कहला जे आपको अकाउंट को बैंक रो को अकाउंट को जाईची बोली स्पेशल एंड एक्विजिशन ऑफिसर जगतसिंहपुर कहले
Page 9 Magna Glass.
पेज 9 এটা দুইটা अमाउंट गोटे होची এটা 8 रे होची 4,11,704
Second 71.
71 होची सेकंड पेज रे अच्छा
Subject cited and inferring that an amount was paid for e-transfer to the account. E-transfer.
Account number check করুন ঠিক আছে
Navinaran Sambal for sale amount. Once e-transfer, there cannot be any doubt that amount is not.
अच्छा এই अकाउंट आपन को बैंक रही
It ICICI.
ICC Bank और Kannada Bank.
It is Kannada.
सेकंड होची कन्नड़
चेक করুন कोई सस्पेंस अकाउंट रे पड़थिबो
मना करते
ताकू पक्ष करचंदी
आया 3 and 4.
रिप्रेजेंटेशन देले कोन आउ चाहउजन जाओ
It is a central bank or in the Kannada bank.
सेंट्रल बैंक
Receipt detail देना है.
वो ब्रांच तो कोई
जगतसिंहपुर कोन गोटी ब्रांच अछि आपनकर आईसीसीआई रो
सेंट्रल बैंक लिखछन्ती गुटे सेंट्रल बैंक रे अकाउंट अछि आपन
Kannada Bank
तो सेंट्रल बैंक इंप्लीट करछन्ती आपन
नहीं सेंट्रल से भूल को सेंट्रल बैंक को जाई अनेक्टर 8 डिस्ट्रिक्ट सेंट्रल बैंक. ठीक है
सर
ब्रांच मैनेजर प्रथम अपोजिट पार्टी नंबर 3 हला ब्रांच मैनेजर सेंट्रल बैंक जगतसिंहपुर एठी आपनकर गोटे अकाउंट अछि बाकी आ गोटे अछि आईसीआईसीआई बैंक जगतसिंहपुर आ गोटे अकाउंट अछि नोटिस करिया पूर्व आपन बुझी देबे कि जे शीघ्र ही जो नोटिस करिवे तापर से कॉपी देबे सी आपन बुझी दियंतु हां से लैंड एक्विजिशन ऑफिसर टू बुझंतु एई टाइप रो कंप्लेन आछि कोडी टंका डिपॉजिट
कोई सस्पेंस अकाउंट रे पड़िथियो
कोन हेतियो देखो this writ petition has been filed by the petitioner Ravi Narayan Samal with a prayer for a direction to the opposite parties to release the compensation.
But the alleged by Ravi Narayan Samal, the amount has been credited to his account at Allahabad Bank. Allahabad Bank
Has not been credited.
But has not been credited to Allahabad. In this respect,
in this respect, I am
verify
request
from the account of
get-
the bank. Furnish the detailed report. Whether the amount is credited the above account of the place. Reason for the beneficiary.
it is special land acquisition officer ତାଙ୍କୁ ଲେଖୁଛି ଯେ
ସେଣ୍ଟ୍ରାଲ ବ୍ୟାଙ୍କ ଲେଖୁଛି
ଡାଇରେକ୍ଟ ବୁଝେ ତମରି ଆକାଉଣ୍ଟ କୁ ଆମେ ପଠେଇଛୁ
there is some problem.
ଠିକ ଅଛି କଣ ଲେଖିଲେ
Sir, I filed with the petitioner of the summons is there for a direction of the opposite parties to release the compensation.
oblique ex gratia amount in favor of the petitioner to the tune of rupees 1,704 and rupees 71,156 4,11,544 ଆଉ ଗୋଟେ ହଉଛି 71,156 which have been credited to the opposite party number There are 3 and 4 habo paragraph 1 election 2 and 3 3 and 4 by the opposite party number 2 the land counsel for the petitioner submits that after receipt of the intimation from the special land acquisition officer MIP Jagatsinghpur opposite party number 2 though he verified his accounts at the central bank Jagatsinghpur so also ICICI Bank Jagatsinghpur but he came to know that the said amount has not been credited to his accounts for which he has submitted a representation before the opposite party number 2 to do the needful. Let the land counsel for the state obtain instruction from the opposite party number 2 regarding the details of transfer of the amount in question to the accounts of the petitioners. And if the same has already been transferred, why it has not yet been credited to the accounts of the petitioner in the aforesaid 2 banks. Put up this matter. Keve rakhiya kundu. Put up this matter in the week commencing from 12 तारीख रखी थी देखो 12/5/2025. Yes.
Item 20.
Please, Your Lordship. Lordship, petitioners are petitioner number 1 is a ex-serviceman who fought 1971 war, and petitioner number 2 is the widow of another ex-serviceman who fought 71 war, and petitioner number 3 is the daughter of ex-serviceman who fought Second World War. They all of them applied for Jawan lease during the respective period of time, and it was not considered at that point of time. And in Lordship, in 2014, the Home Department of Odisha brought a resolution that land will not be provided, and in lieu of that, 25,000 cash will be provided to the eligible ex-servicemen who are landless. So this petition, Lordship, the petitioners mainly challenge that resolution under Annexure 6, page 71, which is ultra-vires to the OGLS Act. Because after the enactment of OGLS Act.
No, why have you filed a joint application? If you have applied for separately for lease of the land And obviously, each application has to be considered on its own perspective, whatever available, whether somebody in favor of X, it may be granted, in favor of Y, it may be rejected, or valid reasons. So why have you jointly filed this writ petition? It is not a public interest litigation. You have the argument may be different also, and at that point of time, what is the criteria, that is also to be seen. We file separate writ petitions.
File separate.
The writ petition has been filed by so and so, challenging the Home Department resolution number such and such, the King Lecture.
Annexure 6.
By the annexure 6, no?
Yes.
Up for some time. The Land Council for the petitioner seeks permission to withdraw the writ petition, to file with liberty to file separate writ petition for each of the petitioner. Accordingly, the writ petition is disposed of, giving liberty to the petitioner as such. Yes.
My lord, we are appearing for the OP number of Union of India. Our appearance is noted.
So and so. Now would have election.
6, 7, 8.
Opposite party number
6, 7, and 8.
Okay. Yeah.
Item 21.
Petitioner will approve the Summer Court. The lands of the petitioners are originally belonging to their family under Annexure 1 minor. In the year 1978, out of the entire property under Annexure 1 acre has been acquired by Government of the Soil Conservation Department. That is under Annexure 2 minor. Though the land has been acquired, initially the compensation was given, but that was not sufficient. So that carried in appeal, and in appeal, the compensation was enhanced, but the said amount, to my instruction, the same has not been given to the family of the petitioner. In the meantime, the Soil Conservation Department has shifted to Bhubaneswar mine. The purpose for which it was acquired, that has not been utilized for that purpose. Entire office has been shifted. Only near Christ College, just named under one room is there. For office and quarters of the staff, the land was acquired. My grievance before my lord, I have made a representation, but the government is now taking in action. I am ready to pay the amount which they have paid. The purpose for which it was acquired, it has not been utilized. So the land may be returned to us.
So they may utilize it for some other there.
My lord,
The government has acquired a land.
my lord.
You have been paid compensation amount.
No, my lord, not entire amount. The enhanced.
If you have not paid the entire amount, then the option lies with you to approach, to avail the remedy which are available. Let us say under 64, if you want the enhancement, then you can, that can be, proper application is to be filed.
My
So,
lord,
It was acquired under the old act.
my lord. But your lordship, I am inviting my lord's kind notice section 20.
but if the full amount is not paid and 2013 Act comes
My
into
lord,
force,
my lord.
then the provision is there in section 64 that you can ask for that and before the collector to refer the matter to the competent authority for adjudication, and if the collector within that time stipulated does not refer it, then he can approach the authority directly, so that he can make a prayer to refer the matter to, and accordingly the same would be done. So have you exhausted all those remedies?
No, my lord. Only I have given a representation to the collector, but no steps have been taken.
So question of dissatisfaction with the amount paid to you,
My lord.
there are alternative remedy available to you.
But my lord,
If your prayer is that those lands for which you have been given already compensation, and if you have not hesitated before the appropriate authority regarding your grievance for enhanced compensation, then it will be presumed that you have no grievance at all. Then you are satisfied. So why the land will be given back to you?
Your lordship, kindly section 24.
24 will not help you.
And
Compensation is not paid, or physical possession is not taken, or is to be read as ended.
my physical
That's the
possession has
judgment.
not been taken till now.
That's the then
That is-
compensation is partly paid.
Compensation is a part of it. That is the
Pune
decision.
municipality is over.
Yes, my lord. I
That's
have
overruled
That is
already.
that
No.
or
one
has been
judgment last
interpreted to
week
be
I
hard.
had,
Justice
That
Arun
is-
Mishra's judgment. You see.
that is Indore Development Authority.
Yes.
There are some guidelines have been framed, my lord. Indore Development Authority case.
Where is the earlier notification section 4.6? Do you have that?
The petitioner has not filed a single document to show that
You have not filed 4.6 notification. Then your resort is section 48 of earlier act.
Yes, my lord.
You have to give representation for section 48.
But now
The denotification.
in your new Act, my lord, 2013, as per 24, the surplus 2 and proviso, only I am placing that. With my lord's permission. I have quoted in the read petition.
24, once you have got the compensation, matter ends there
My
because
lord,
of
the
that.
entire, my lord, my submission before my lord, the entire company will receive.
Now then the alternative remedy is available to
My
you
lord.
under
My lord.
64.
Yes, my
64.
lord. There I am, when the, so with my lord's permission, section 24(2), not returning
Eight.
anything.
2015.
I have quoted my lord in my
8
read petition.
page 8 quoted.
And page 7.
Wait.
Notwithstanding anything contained in subsection 1, in case of land acquisition proceedings initiated under the Land Acquisition Act 1892,
Compensation.
for an award under the said section 11 has been made 5 years or more prior to the commencement of the act. But physical possession of the land has not been taken.
Rather, you have to resort to 64 or 48 of earlier act.
Section 24 surplus 2 read with section 101, my lord, of the new act. Because here, my lord, if there is a proviso, 7/24(2), provided that where an award has been made and compensation in respect of a majority of the holdings has not been deposited in the account of the beneficiaries. Here.
Has been interpreted in that judgment. Even if it is deposited in the treasury, that is treated to have been paid to you. And in your case, partly you have received.
My lord.
Then section 24 goes straight away.
And regarding this dissatisfaction, claiming higher compensation, remedy is available under section 64.
Now we cannot, my lord, dissatisfied because already once they were dissatisfied and it was enhanced and that has not been paid. But my lord, section 24 read with section 101, my lord, more than 5 years it is in that. Now, till now, the property is under
101 you have applied the authority's discretion. They may denotify. They may denotify.
Act 2013 won't be applicable to this case.
My humble submission, till now the property is under possession, my lord. Now they have issued a notice for demarcation since 1978.
See the acquisition is in the earlier act.
My lord.
Unless it is lapsed.
Yes, my lord.
New act will not be applicable to you.
But in
lapsing provision is 24. These are the difficulty you have.
Act 2013 itself is not applicable.
You just see old act section 48 may help you.
Your lordship kindly call it next week, and my lordship is referring the judgment. Let me go through it because I have come with the
Wait for by the land
Indore Development Authority judgment.
petitioner. List this matter next week. Yes.
My lord's reference to my lord's permission.
And or जो हिजमो से डिसेंड अप
Justice Arun Mishra
और तको implicate करिसेंती and
Indore Development will refer to
we see that. Yes.
Item 22.
Next week.
Yes, next week. One week after.
Section 34 would be the appropriate remedy. Selling the award passed by the appropriate.
Next, which one?
Item 22.
22 is seeking for an adjournment.
Okay.
Yes.
Item 23.
May I please, Under the order of dismissal dated 19/20/24 passed by the Lord CT Kotak Mishra Kotak under Annexure A by 12 manner is the order impugned in this petition manner.
What was your prayer before the?
Well, I have a challenge.
Come to the order, page number 49.
Fine.
Internal page is 2.
Fine.
See the prayer portion.
To quash the order of rejection dated 30th December 2020 under Annexure A by 8 P and to direct the respondent to the form 21st 11/1986 to 11/2/1991 as qualifying service for grant of upgradation under MSC scheme and to direct the respondents to grant third finance operation under MSC scheme with effect from 11/2/2021 and fix the pay accordingly. D. And to direct the respondents to pay the differential financial benefits, that is arrear salary, leave salary, discharges, commuted value of pension and arrear pension. And E. To pass any other orders at this tribunal deems fit and proper in the interest of justice. May I pray, my lord? Can you give a glance to the original independent order with the subject matter before the law tribunal? December 2020. Or December 2020.
Which one?
Page 29. I am placing that order. I am directed to refer you the office order letter number so and so dated 19/28/2020 on the above mentioned subject and to say that in view of government instruction in para number 25 of DOPT and 19/5/2009 and para 24 of OM dated 22nd/10/2019. SMT S. Patra, senior assistant, would not eligible for third finance operation, though he will be completing 30 years of regular service on 11/2/2021. Since our second MSCP was deferred for 1 year, that is 11/2/2012 instead of 11/2/2011 match, due to debarment for refusal of regular promotion. In accordance with para 15 of the above both, there will be consequent effect on subsequent final operation under MSCP and thus the third final operation of the officer, if admissible, would also require to be deferred by 1 year as has been effected for second final operation under MSCP. May I pray, my lord?
What is the scheme, MSCP scheme?
My lord. Annexure.
Annexure. 5.
Start from page 18.
Relevant কথা পড়িলে
para they have while denying third operation, my lord, they have referred para 15, my lord. You also kindly give a glance. Para 15 is at page 24 of my resolution.
Para 15.
My lord.
Acha, page 24. Huh?
My lord, stop. If a finance operation under MSCP is deferred and not allowed after 10 years in a grade pay, due to the reasons of the being unfit or due to departmental proceeding, etc., this would have consequential effect on the subsequent final operation, which would also get deferred to the next extent of delay in grant of first finance operation. Well, challenging the order to impugn, I approach to saying that this para is not applicable to my case as because neither I was ineligible nor any department proceeding was initiated against me. But I refuse a promotion. Admittedly, I refuse a promotion because by I had to face order transfer from Kotak bench to Bombay bench. Being a lady employee, I refuse. Like this is the fact, man. So accordingly, I challenge that order. They have filed a counter. In the counter, they have taken shelter of para 25 of the MSCP scheme, man. Now, my only submission before
what is para 25?
Man. Next page, man. If a regular promotion has been offered, what was refused by the employee before becoming entitled to a final operation, no financial operation shall be allowed. As such, an employee has not been stagnated due to lack of opportunities. If, however, financial operation has been allowed due to stagnation and the employee subsequently refused the promotion, it shall not be a ground to withdraw the financial operation. He shall, however, not be eligible to be considered for further final operation till he agrees to be considered for promotion again And the second, the next final operation shall also be deferred to the extent of period of debarment. So they have applied this one. So my first submission before my lord is that your lordship kindly give us condition number 1 of the MSC scheme.
Condition number 1 of the
MSC scheme. Page 21. There shall be 3 final operations. 10, 20, 30 years. 30 years. In this case, my lord, why? What is the idea of the scheme? You tell me. My idea of scheme is where there is no stagnation. Promotions, man. You should get the benefit. There is no stagnation. You refuse. A promotion was granted to you. You refuse. No, my lord. So far, the scheme doesn't apply. So far, that part is concerned, they have due to stagnation, they have granted me, man. Subsequently. Can't have both. Dividing 1 year period, man. Dividing 1 year period. My submission before mandate that I have lost the benefit of 1 year final benefits, man, by way of debarment of my legal entitlement on the ground of refusal of regular promotion. So, my lord, now they are saying no, that 1 year will be entirely deducted total qualifying service. So on completion of 31 years of service, you will get one. Third one, my lord. So well, that is so then this goes straight away against condition number 1 of the scheme. My submission before murder, I refuse. So I punished by a denial of 1 year final benefits. Mine was 11. They granted me for 12 months.
1 year will court provision. 1 year you provision, set a court provision.
That is para 25. But my page 29.
It's a 109 something.
If the regular promotion has been offered, but was refused by the employee before becoming entitled to final operation.
Yes.
If, however, final operation has been allowed due to stagnation and choice, subject refuse the promotion, it shall not be a ground to withdraw the financial operation. He shall, however, not be eligible to be considered for further financial operation till he agrees to be considered for promotion again, and the next final operation shall also be deferred to the extent of period of debarment due to refusal.
So how does it this favor them? That is why they have relied upon this provision.
But how will you get out of this provision? 25. My first submission before my
Provision number 1 set as a general provision. By way of exceptions to rules. Condition number.
I am not able to collect any decision on this issue. The issue involved, my lord, whether that debarment will be for 1 year by your punishment in lieu of refusal of promotion, or that 1 year will be completely deducted from the entire qualifying service. Suppose I have completed 30 years. Because of debarment, that's a you will not get. You have to complete 31 years service. No, it is 1 year. They have deferred. You get in 31 years. So, my lord, what is the question? So, my submission that para is not clear. That on completion of 31 years, you will get the third one.
Even if this condition number 15, according to you, will not be applicable, though they have relied upon, because you are not declared as unfit, or no departmental proceeding has been initiated. But how do you overcome this 25. Number 25?
25, my lord, my submission before my lord, I am raising an issue to be decided by my lord. Whether I will be deprived of the benefit of 1 year, or 1 year service will be completely deducted from my entire service. It will be deferred for 1 year. In every 21, you will get 11, 21, and 31. That's the meaning of this 25. So, my submission before my lord, an issue I have raised, your lordship is here to decide. Let them file. Then, my persons, in the input order, they have not taken para 25. By way of counter, they have raised this for another matter.
So I have relied upon judgment of Honorable Apex Court. In case of KPS Gilman, sorry, that judgment of MS Gill. They cannot take any new plea to subsequently substantiate the order of rejection, original order of rejection.
Which decision?
My lord, Mohinder Singh Gill versus the Chief Election Commissioner of New Delhi, year 1978, Supreme Court, 851. I have quoted para 8 of the judgment, page 9 of the
78 Supreme.
851.
Yes.
If
But-
the procedure is given, you have to go as per the procedure. The manner in which the procedure is prescribed, you have to.
So that is that Nazir Ahmad case or
See the same principle.
same principle. 36 Privy Council 253.
Same principle is followed.
This is a considerable judgment, madam. Decisions, no subsequent development can be made in the counter to substantiate the original order of rejection.
The writ petition has been filed by the
My lord, in
petitioner.
this case, I am appealing for the opinion number 1 to 4. My lord, kindly come to the page 26
To accept notice and file your counter affidavit.
of the
This petition has been filed by petitioner Sanjukta Patha, challenging the order dated 9/10/2020, passed by the Land Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 524 of 2021. So the aforesaid OA was filed for a direction to the opposite parties to compute the period from 21/11/1986 to 11/2/1991 as qualifying service for grant of up-gradation under MACP scheme. And for the direction to grant third financial up-gradation under the MACP scheme with effect from 11/2 and to pay the effects pay accordingly. And for further direction to the opposite party to pay differential financial benefits, that is arrears salary, leave salary, DCRG, commuted value of pension and arrear pension, and to pass the rejection order dated 30/12/2020 সেটা কে পাস করতে সে রিজেকশন অর্ডারটা
Response number opposite party number 3, my lord.
passed by opposite party number 3. The land council for the petitioner submitted that in view of Rule 25 of the MACP scheme, the Land Tribunal has rejected the prayer made in the original applications. However, he submits the scheme itself indicates that there shall be 3 financial upgradation under MACPS counted from the direct entry grade on completion of 10, 20, and 30 years of service respectively. And financial upgradation under the scheme will be admissible whenever a person has spent 10 years continuously in the same grade field. And so far as condition number 15 in the aforesaid scheme is not applicable to the petitioner, as he was never declared as unfit or any departmental proceeding was instituted against him. Debarring applicability of finalization under the MSEU. So far as condition number 25 is concerned, the Land Council for the petitioner submits that the Land Tribunal has wrongly applied such provision in the case of the petition. That are Rule 25, that a condition actually. That is rule, for example. Rule. That are just a condition on the in place of rule, for example. The question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the Union of India accepts notice on behalf of opposite party number 1. Extra copy of the writ petition be served on the Land Council. No notice be issued to the opposite parties number 2, 3, and 4. Put of this matter after 4 weeks counter affidavit pending be filed in the meantime.
You're subordinated already.
Malice.
Well, my appearance. The appearance one. So also filed the appearance. Okay. Yeah.
Item 24.
In this case, the petitioner belongs to the land family, whose land has been acquired by Orissa manor in the year 88 manor. Uniform guideline was prepared as per Annexure 1, and the lease was prepared as per Annexure 2 manor.
What is your grievance now?
We seek for employment manor.
Employment.
Yes, sir. Annexure 3 manor, one mistake was filed before the college as per the writ petition filed in 25425 of 23.
You have been provided with the compensation amount. Only grievance is that you have not been given employment. So worry that provision that it will be given to you under that policy.
Guideline as per Annexure 1.
Age 11 plus 4 manor.
Plus 4.
Employment. A, B, C, D. E. 5 categories are.
Upon who category ashanti?
D.
D category belongs to the land of
1 member of each family. B for Bombay.
No, but D.
D. Besides contractors working under so shall provide employment according to their requirements to the member of displaced family according to eligibility of so will prepare a list of such persons to be provided employment and supply the name to the contractors working on copy to the collector.
Well, let kindly have a glance to Annexure 2, page 13. Serial number 3. Uha Naik. He nominated Santha Naik.
Yes.
Son of the Uha Naik. Uha Naik is the recorded tenant. Nominate karla se thai rahi au jana puas ni coach. And his age is kindly have glance to the age. 58.
Got any employment minor. This has been challenged in writ petition number 25431 of 20.
D रे तो employment दवा पे भी मध्य किसी नहीं. D category यदि contractor पाहे किसी काम थाए contractor engage करियो. Employment पे
challenge that kindly see order Annexure 3 my lord last portion. The above findings, in my producer's opinion, it is a fact that an area of tenancy land has been acquired under Land Acquisition Act 1894 for
land acquisition
in 88 manner.
88. So, सेटा पर्यंत कौन करथिले 2025 पर्यंत
that has been challenged manner.
तो आपण बयस हेलानी 58 वर्ष अभी आपण से की एम्प्लॉयमेंट दबो आपण से कॉन्ट्रैक्टर जो वाइज कॉन्ट्रैक्टर पाके किसी काम थिबो ताले सी आपण को दबो बोली जो आप डीटा पढिले वर्तमान आपणकर 88 ମସିହାରେ ଆପଣ କେତେ ବର୍ଷ ପରେ ଆସୁଛନ୍ତି ହାଇକୋର୍ଟକୁ? 25 ଏବଂ ପ୍ଲସ୍ 12 ହେଲେ 37 ବର୍ଷ ପରେ ଆସୁଛନ୍ତି। ଦ୍ୱିତୀୟ କଥା 58 ବର୍ଷ ହେଲାଣି ଆପଣଙ୍କୁ କଣ ହେଇଛି?
challenge my lord before the authority.
ହୁଁ
Time to time it has been challenged before the authority, my lord. In Annexure 3, my lord, then the general manager challenged the order of collector in Annexure 5, my lord, and that has been dismissed.
Annexure 3 was filed in the year 2015, and in that serial, the name of the petitioner was also not there.
It was rejected. There is a delay of 28 years.
The Honorable High Court granted, collector directed MCL authority to give employment. That was challenged before this Honorable Court. Honorable High Court also confirmed that order, and that was challenged before Supreme Court. In Supreme Court also confirmed, but the petitioner
how
name
to
is not.
explain this delay in approaching the court, delay and laches re ଆପଣଙ୍କର really you sought for question, it can be dismissed on that ground alone. You are the cause of action arose in 1988, as you said. The lands were 1988 and compensation have been paid. So thereafter, so many years have passed, and that is also somebody else has been nominated, and you are nowhere in the picture. After these years, you have come, and when the provision says that if the contractor has got any requirement, then you may be given. So these are the hurdles in your path.
Should be given
But ଆପଣଙ୍କ ରେଫର କଲେ ଆପଣଙ୍କର ମା ଯାହା ନାଁରେ ଜମି ଅଛି ସିଏ ରେଫର କଲେ ତାଙ୍କ ପୁଅକୁ ସନ୍ଥ ନାୟକ। So Santha Naik
has not get any employment, my lord. At that time, I was minor, my lord.
So where have you stated that Santha Naik has not got any employment? Have you taken such averment in your writ petition? ସବୁ ଜିନିଷ ମୌଖିକ କହିଲେ ହବ କି? ପରେ ଆପଣ ଆସୁଛନ୍ତି।
And present petitioner is the grandson of Naik.
Should be a rehabilitation scheme to address the immediate situation.
Has been filed by the petitioner Antaryami Naik, who is about 58 years, with a prayer to provide him employment as per R&R policy in lieu of the land acquired, provided LA case number 26 of 1985. It appears that the land stands recorded in the one Montana
KUHAN Naik.
Serial ta kete?
3.
3 number. Kuha, KUHAN, Kuha Naik, son of Damodar. And he has received the compensation amount, and so far as employment, he has nominated his son, SNTHA, for such employment.
Guideline 14, 40.
In the guidelines, 26/1988, under Annexure 1, under Clause 4, under the heading of employment, 4 bracket D kar diyantu. It is stated as follows. 4 D ta quote kar diyantu, page 11, right? The Land Council for the petitioner submits that though Puha Naik recommended Santha Naik for the employment, but Santanayak has not been given any employment. No such averment has been taken in the writ petition. The cause of action arose in the year 1985, na?
88.
88. In the meantime, 37 years have passed, and the petitioner has not offered any explanation regarding delay on his part to claim such relief. When the writ petition merely the submission made by the land counsel for the petitioner that the petitioner was approaching different authorities during this period is not sufficient to condone the delay, inordinate delay for them, the part of the petitioner to claim the relief as sought for. Moreover, the clause 4D of the guidelines dated 2688 indicates that if the contractors have requirements then the employment can be given to the members of this family.
Coming under category D.
Coming under category
D.
Category B.
D. ABCD. D for delay.
Coming under category D. In view of the absence of the pleading to the effect that the shown of the recorded land loser, that is Kuhanai, has not been given employment, and in view of the inordinate delay in approaching this court, we are not inclined to entertain this writ petition, which is accordingly dismissed. Yes. I want to mention my lord. I want to mention my lord. I think file for the interim bill.
Weekly list item number 1.
May I please your lordship?
Yes.
My lord, the appellant was convicted under section 302 and sentenced to arrive for life, your lordship.
For the trial court record, interim applications for bail and stay relation of fine to be considered after receipt of the trial court report. Land counsel for the appellant shall supply the deposition copies of the witnesses to the land counsel for the state in the meantime. Yes.
Item 2.
When your appellant is convicted under section fresh matter, no? Yes. So ଏଗୁଡା କଣ connected appeals ମାନେ ଆସିଛି? Yes, sir. Connected appeal ଅଛି 29 admit କରିଦିଅନ୍ତୁ। ତା ଦେହରେ trial court ରେ ଆସିଯାଇଥିବ ବୋଧେ। It is stated that in the connected criminal appeals, the trial court record is available. List this matter along with serial number whatever they change. All right, next.
Item 3.
The informant is the appellant against the acquittal granted by the learned additional session judge from session judge Contaband under 302, 201 and 120B of the Indian Penal Code.
So, Mishra Naik, whether there is any proposal from the government side to prefer any appeal against the order of acquittal, that instruction you take. This heard Mr. A.P. Bose, this criminal appeal has been filed under section 3 CRC. Upon better 2025 ରେ appeal କରୁଛନ୍ତି 372 କେମିତି ରଖିଛନ୍ତି?
That wrongly it has been typed there. It should have been under the BNS Act.
BNS Act appropriate provision ଲେଖିନି।
That is mistaken.
Which corresponds to the word used for 372 of corresponding provision. Challenging the judgment and order dated 7th 2025 passed by the additional session judge from special judge Contavanji in sessions case number 70 of 2022 in acquitting the respondents number 2224 of the charges under section 302 public 201 public 120B of the Indian Penal Code. The appellant is the informant in the said case, which arises out of Contavanji PS case number 332 of 2021. Let the land counsel for the state obtain instruction as to whether state is challenging, contemplating to challenge the impugned judgment and order of acquittal or not. केवे रखियो कौन? Public prosecutor को contact करिवे। तापरे सिर्फ recommend करती वो law department इबड़ा सुवानी किन देवे। After vacation or after summer vacation.
So that is notice to be discussed.
No, आसी जाओ, चले आसी वाला पूरा हो। Next.
Item 4.
May I please? Remember, the appellant has been convicted of the offence under section 302 of IPC and sentenced to RI for life.
Same order. Admit.
And here, my lord, LCR is available in the connected case.
अच्छा। CRL number 207 of 2022 रे।
आइए।
आप आपसे देवरे केमती फाइल कले कौन भाई? Judgment केवे करा?
Judgment है 3/4/25.
अपन केमती कुछ जे same judgment is under challenging in 2022 criminal appeal.
It is split up record type.
Split up ପରେ ଆଉ କିଛି ଅନ୍ୟ ସାକ୍ଷୀ ହିଁ ନାହାନ୍ତି।
ସାକ୍ଷୀ ହେଇଛନ୍ତି।
ତାହେଲେ ट्रायल कोर्ट रेकॉर्ड टा गोटे केस रा आछि
अलगा थिबो ना
जो केस रो 2022 रे डिस्पोज ऑफ हेई जाइछि
आगे
तापरे आपण फेरार हेले आपण हाजर हला परे अन्य साक्षी निया गले तो सेम ट्रायल कोर्ट रेकॉर्ड केमती नो कॉल फॉर करी किनी सेही ट्रायल कोर्ट रे हबो कुछ पर्यंत
आगे
देखो कॉल फॉर द ट्रायल कोर्ट रेकॉर्ड बाकी अन्य जहां लिखियंती डिपोजिशन कॉपी टू बी सप्लाइड यस
एडमिट में
This is admitted that he has to supply with the deposition copies and it is to come after the receipt, that is for consideration of the bail and stay relation application. Yes, next.
May I submit one thing, my lord, in this case? In particular case, my lord, split of trial, my lord, two set of evidences were recorded of the cases. First, they have given evidence in respect of one appellant. Thereafter, after 1.5 years, they again came and again.
Mr. Mishra, the evidence might be little different. Who knows?
Yes. That will come both the records.
Whether two set of evidence can be recorded, my lord. Whether two set of evidence.
No. Suppose the accused was not present when the evidence in the other case has been recorded.
Yes.
So in his presence, it is to be again recorded. Not that the chief examination, whatever has been done, you will just given the opportunity of just putting some question. The entire evidence is to be recorded in presence of an accused who is subsequently arrested. Not that X trial face kala, ta evidence record gala, cross examination hai gala, ta dhire eti khali add haba aponu khali cross examination aponu.
ଗୋଟେ particular witness ଆଜ୍ଞା ଆସିଲା PW1 ଆସିଲା PW1 ଯାହା କହିଲା ଯିଏ ଫାର୍ଷ୍ଟ ଯିଏ ଟ୍ରାଏଲ ଫେସ୍ କରିଲା ତା ଏଗେନ୍ଷ୍ଟ ଯାହା କହିଲା ଯାହା ସେ କହିଲା ଏଭିଡେନ୍ସ ଯାହା କହିଲା କ୍ରସ୍ ଯାହା ହେଲା ସେଇ PW1 ପୁଣି ଯେତେବେଳେ ଏଇ କେସରେ ଆସିଲା କ୍ୟାନ୍ ହି ଟେଲ୍ ଏ ନ୍ୟୁ ଷ୍ଟୋରି
ଆରେ ନ୍ୟୁ ଷ୍ଟୋରି କହିବାକୁ କିଛି ମନା ଅଛି
ଦେଖିବା why you what yes
whether if he said in a different way
yes he said
you can say that in such trial when you are examined as PW so you stated in this manner, so the previous statement has to be confronted. So the question is that he cannot, he may say that yes he was facing trial, I said like that. Now he may, so it is not whether he would be facing a trial proceeding for perjury or not, that's a different matter. But you cannot say that he is bound to say the same thing. Obviously, he has taken oath. He may not.
Possible example. Yeah. That criminal appeal is also there in my lordship's board.
No, that's all right.
207.
Yes.
Yes, next to this.
Item 5.
My lord, prisoner petition is there, my lord. Our main memory will be taken over.
Engagement of Mr. Debaki Marandi. Here, Chanti, Debaki Marandi. Debaki Marandi की एडवोकेट जानते हैं सेठी का लोकल लोन से कर दी थी प्रैक्टिस नथिबो ठीक मो ललाटन समुद्र को केवल नियुक्ति करथिली किंतु वर्तमान मोर भरोसा सुनांछु ताको बाद दी नूतन भाव में देवकी मारांडी को हमर हाईकोर्ट प्रैक्टिशनर व्हाट से लोक केउझर एडी किए ताको कहि दो से ना लिख देथियो अब एंगेज कर देले असुविधा हो माने जेतो उठुथिबो मैटर से नथिबे से बाबू गोटे काम करूँ ना से केउझर जे ये जेलर को कोन से लोक आनी कि वर्चुअल मोड रे अपीयरेंस करिवो हला पचार देले तो रियल डिफिकल्टी टा कोन फेस हो से जानि नथिबो ना
भवानी शंकर दास परस बिलोंग्स टू
की बोले
भवानी शंकर दास
प्लीज सी दैट आइटम नंबर 5 अछि ना
हां हां
आइटम नंबर 5 रे लिखा है कि
बकरनाथ नाम फाइल में कहले 2024 रे इशू
2024 रे भवानी शंकर
प्रेयर हिची किंतु देवकी मारंडी देवकी मारंडी अच्छी तादर ता सहित भवानी शंकर दास
कुमार
लोकल
all right take down the period the prisoner's petition dated 27/2024 ଆପଣ ନା କଣ
ଦେବକୀ ମାରନି
ଆଉ କହୁନାହାନ୍ତି ଆପଣ
ମାଇ ଲର୍ଡ ପେପର
ଟିକେ ରୁହନ୍ତୁ ମୁଁ ଜାଣିବାକୁ ଚାହୁଁଥିଲି ଯେ you are a practitioner of this court or not କାରଣ engaging Mrs. Devani has filed wakalatnama along with Mr. Bhavani Shankar Das and Prakash Kumar Dole as the advocates. The prayer made in the prisoner's petition is allowed. The wakalatnama is accepted. The name of the newly engaged counsel be reflected in the name. He has already been reflected. The name of Mr. Lalatendu Samantray and his associates. Lalatendu Samantray का associates मान का नाम अच्छी तो?
Yes, yes.
Shall not be reflected in the cause list henceforth. अच्छा. पेपर बुक पाई ना थी. 2013 मसीहा. Get a copy of the अपन पेपर बुक रिसीव कर लेगी. पेपर बुक ना दे दो ना. Since Mr. Lalatendu Samantray has received copy of the paper book, the same may be handed over to Mrs. Devaki Marandi. अपन contact करेगी नहीं ऐसे पेपर बुक का, है ना? ठीक है. Date reads 2013 criminal appeal. You have to argue the matter. Okay.
Next week.
Item 6.
Prisoner's petition has been received from jail at flag B regarding engagement of Sushant Tripathi. What are Sushant Tripathi का? Instead of Advocate. Another prisoner's petition at flag E. Upalananda Sahu. Upalananda Sahu तो अच्छा है. ये दीटा कौन पठे दिले अपन को कई जन की appellant जने तो जन trial face कले conviction पे जन कला मैं दी जन तो appellant तो इटा appellant number 1 देची another prisoners गोटे बीटा देखुन ताकि first बीटा की दी बीटा कबल देची मधुसूदन साहु तापर ईटा देखुन मधुसूदन प्रधान तो बीटा को मधुसूदन प्रधान देची गोटे बी मधुसूदन प्रधान इटा डेटेड कितने
husband and wife.
हाँ नहीं जी देची तापमा ये हो ना एंगेज हो ना कौन हो এটা হচ্ছে 26/4/2021 টা প্রথম সে চাইଥିଲେ সুশান্ত ত্রিপাঠী ଆଉ ଏଇଟା ହଉଛି ଲାଟେଷ୍ଟ 12/3/24 ରେ ସେଠି ଲେଖିଛନ୍ତି ଗୋକୁଳାନନ୍ଦ ସାହୁ ଆପଣ ଓକାଲତନାମା ଫାଇଲ କରି ସାରିଲେଣି ଅଛି ଓକାଲତନାମା ଅଛି ଇଏ କରିଦିଅନ୍ତୁ ଫିଲ୍ ଅପ୍ କରିଦିଅନ୍ତୁ ହେଲା ଲେଖନ୍ତୁ period the prisoner's petitions कर देंगे at flag B and flag E. Flag B edition dated 26/4/2021 in which request has been made to engage Mr. Sushant Tripathi in place of Mr. Satyavrata Panda. And in the prisoner's petition dated 12/3/2024, which is at flag D, a request has been made to engage Mr. Gokulananda Sahu as his advocate. By it was appellant number 1 कर दे मधुसूदन प्रधान है ना सेटा भी to engage Mr. Gokulananda Sahu in place of Satyavrata Panda. Since the prisoner's petition at flag E is a more recent one, we engage Mr. Gokulananda Sahu as the advocate for appellant number 1, Madhusudan Pradhan. The आरो जनक सी रहिले सेमती एडवोकेट सत्यव्रत पंडा
He cannot appear right now because
he cannot appear बुझिले ना ତାକୁ କୁହନ୍ତୁ ଏଥିରେ 2 ଜଣ ଆପେଲାଣ୍ଟ ଅଛନ୍ତି, ମଧୁସୂଦନ ପ୍ରଧାନ ଅଛନ୍ତି ଆଉ ପାର୍ବତୀ ପ୍ରଧାନ ଅଛନ୍ତି। ଆପଣଙ୍କର କେବଳ ଏନଗେଜମେଣ୍ଟ ହଉଛି ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ପାଇଁ। ଯଦି 2 ପାଇଁ ଇଏ କରୁଛନ୍ତି ତାହେଲେ ସିଏ ତାକୁ ଗୋଟେ ପାର୍ବତୀ ପ୍ରଧାନକୁ ଗୋଟେ ଦରଖାସ୍ତ ଦବାକୁ ପଡିବ ପ୍ରିଜନର୍ସ ପିଟିସନ ଆପଣଙ୍କ ନାଁରେ, ତାହେଲେ ହେଲା। ତେଣୁ Mr. Uklananda Sahu is present in court. Pills of the Wakalatnama of Madhusudan Pradhan, which has been received along with the prisoner's petition at Plagi. The same is accepted. The name of Mr. Sushant Tripathi shall not be reflected in the cause list henceforth. Okay, next.
7.
Item number 7 by order of 6/3/2025. 6/3/2025. Lost for directed whether to take instruction whether any appeal has been filed regarding Chandipada PS case number 46 dated 9/7/1997, in which the present appellant was accused of. Inadvertently, a CD has been forwarded to. Can I pray for next week? And in the meanwhile,
while going with after the petition earlier faced trial in Chandipada PS case number 46 dated procedure नालसा ये मुझे आपको रिलीज करिया को petition
yes, sir.
देइची।
I'll take instruction as to the special condition regarding the appellant.
सेटा तो नेबे आपनो तार एज विषय नेबे कान से कैंपेन अनुଯାयी 70 years ever basically. It applicable to the old prisoners or terminal age prisoners. The old prisoners category per the assistance to in accessing from the earth provide medicine support to the old prisoners and mental ensure सक्रिय वर्ष जो फॉर्म दर अच्छे सॉरी फॉर्म तक जो अटैच कर 70 years category age about 70 years sorry means other what ethi rahichi release on compassion of older prisoners who are in need of constant specialist nursing care and who do not pose a risk to the society. तो खाली 70 वर्ष हेले होनी ସେମାନେ ଏଇ ଦିଟା ସେ ଦିଟାରୁ ସେମାନେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବେ
only for release.
Release on bail.
It seems he is suffering from schizophrenia. It seems he is suffering from schizophrenia. I'll take instruction.
Although you take instruction, whatever.
You already got the information.
That is the letter sent by the Nalsa. In column number 16, the regarding the medical
district legal services authority, ସେମାନେ ସେ ଫର୍ମ ତାକୁ ଫିଲ୍ ଅପ୍ କରି ପଠେଇଦେଲେ ଏଠି ଆସିଲା ପରେ ସେମାନେ ଆଡଭୋକେଟ ଏଙ୍ଗେଜ କରିଦଉଛନ୍ତି ଆମର ଯୋଉ ହାଇକୋର୍ଟ ଲିଗାଲ ସର୍ଭିସେସ୍ ଅଥରିଟି କଲା ପରେ ଆସୁଛି ବେଲ୍ ପାଇଁ ତ ସେଠି ଇନଷ୍ଟ୍ରକ୍ସନ ମିଳେ ये जो बॉस लिखा है 71 ସେଟା ଠିକ ହିଁ ନାହିଁ ତାପରେ in accordance with the so the land council for the state seeks some more time to obtain instructions as per the order dated 6/3/25. एवढा देखो एवढा शीघ्र हवा का था ऑर्डर नहीं था
next week
नालसा गाइडलाइन ଅଛି ଆପଣଙ୍କ
advertisement
ଏନା नहीं out of this matter on 30 तारीख रखुଛୁ 30th of April का
Item 8.
your instruction
notice has been served in the information.
no that has also been you are to you say the order is very clear
yes
whether they have been intimated that a counsel from the High Court legal services committee can be provided to them to oppose the application for bail. ସେ କଣ କହିଲେ?
In the submission with the format in which they have submitted.
ଖାଲି ନେଇକି ଇଏ କରିଦେଲେ ସିଏ ଭାବିବେ ଯଦି ନାଇଁ ଆଜ୍ଞା ଆମେ ଗରିବ ଲୋକ ଆମେ ହାଇକୋର୍ଟ ଗଲେ ପଇସା ଖର୍ଚ୍ଚ ହବ ଆମର କଣ ଦରକାର ସେ ଚୁପଚାପ ବସିଯିବେ।
So may I read the
ସେଇଥିପାଇଁ ହଁ କଣ
ଏତଦ୍ୱାରା ଆପଣଙ୍କୁ ଜଣାଇ ଯାଉଛି ଉପରୋକ୍ତ ମକଦ୍ଦମାର ଆସାମୀ ଅଫଜଲ ନାୟକ କାର୍ତ୍ତିକ ପିତା ସ୍ୱାଂଶ ନିବାସୀ ସ୍ୱାଂଶ ଜାମିନ ମଞ୍ଜୁରୀ ନିମନ୍ତେ କ୍ରିମିନାଲ ଅପିଲ ନମ୍ବର 360/2019 ଦାୟର ହୋଇଅଛି। ଏଣୁ ଆପଣ ଆସନ୍ତା 21/4/2025 10ଟା AM ଘଟିକା ସମୟରେ ମାନ୍ୟବର ହାଇକୋର୍ଟ କଟକ ଠାରେ ହାଜର ହେବେ କିମ୍ବା ଆପଣଙ୍କ ଓକିଲଙ୍କ ଜରିଆରେ ମୁଦାଲାର ବେଲ ବିପକ୍ଷରେ ଲିଖିତ ଅଭିଯୋଗ କିମ୍ବା ଯୁକ୍ତି ଉପସ୍ଥାପନ କରିପାରିବେ ବୋଲି ଆପଣଙ୍କୁ ଜଣାଇ ଦିଆଗଲା ନଚେତ ସରକାରଙ୍କ ତରଫରୁ ଓକିଲ ସହାୟତା ଯୋଗାଇ ଦିଆଯିବ।
ସେ କଣ କହିଲେ?
They have received the notice. That is the endorsement, that is the signature. The mother of the deceased and victim.
ନାଇଁ ମ purpose ଟା ଗୋଟେ ଅଲଗା ପ୍ରକାର।
Yes, no.
yes no ଗୋଟେ ଆଣିବା କଥା ନା। ସେ ଯଦି କହିବେ ନାଇଁ ଆମେ ଓକିଲ ଦବୁନି କି ଆମର ଦରକାର ନାହିଁ ସରକାରୀ ଓକିଲ ଅଛି।
I'll take instruction to that.
ଯୋଉ purpose ପାଇଁ ରହିଛି ଏଇ particular offense ରେ ତାଙ୍କୁ ଶୁଣିବ ବୋଲି ସେଟା frustrate ହଉନି ଯାହାର
ଯିଏ ନୋଟିସ ନେଇକି ଯିବ ଇଏ ତାର ଷ୍ଟେଟମେଣ୍ଟ ଟା ରେକର୍ଡ କରିବ ପଛରେ
whether they want to engage through yes sir. I'll take specific instruction to that.
ଏଟାର ସିଲ୍ ମରା ହେଇଗଲାଣି ଏଟା ଆପଣଙ୍କୁ ଦିଆହେଇପାରିବ।
Let that be reported. I'll take instruction to specific instruction.
That should be standard instruction to all.
Much.
The Italian Council for the State submits that the notice has been served on the informant on 3/4/2025, but she may be given some further time to instruction as to whether the informant has any objection if a counsel from the High Court Legal Services Committee is provided to him to oppose the application for bail, if he is unable to engage an advocate on his own to oppose the application, bail application.
Yes.
Free copy of the order be given to him. Put of this matter on such and such. Paperbook
has been prepared. A paperbook has been prepared. A copy may be there.
Copy of the paperbook be handed over to the Land Council for this.
Subject to your lordship's acceptance, my lord. May I submit only one thing, my lord? On the last occasion and on various occasions, I have tried to convince your lordship. But it lordship at page 55 may kindly be for a moment, man.
No. Yes, next.
No, this is a case under section 376(2)(I), on which I have.
So,
but 376(b)(A) accused has already been granted bail.
All right.
But I have not been convicted under section 376(b)(A), man.
Next.
Item 9.
Lordship, adjourn it.
It will come after वकालतनामा फाइल कर 8 रोड
Item 11.
So 11 Miller.
Interview application is filed by the call for hearing.
Or you are not short for the instruction. Item Miller of
7/4/25 रे order हला on the ground of ailment of the mother of the petitioner. Copy of the medical prescription has been enclosed. এবং সেତେବେଳେ মিস বিজয়লক্ষ্মী ত্রিপাঠী କହିଥିଲେ যে she has already received the interim application and also medical document ଏବଂ ସମୟ ମାଗିଥିଲେ ସମୟ ଦିଆ ହେଇଥିଲା ସେଇ 21 ତାରିଖକୁ ଆଜି 2 ସପ୍ତାହ ପରେ ରଖାଗଲା ଆପଣ ସେଇ କଣ କଲେ ମ୍ୟାଡାମ କଣ କଲେ ମିସ୍ ତ୍ରିପାଠୀ ଫାଇଲ ପତ୍ର ବନ୍ଦ କରିଦେଇ ଘରକୁ ପଳେଇଲେ କିଛି ଲେଖିଲେନି
Item 12.
So 12 Miller. Receive the Vinama.
ଆଗରୁ କଣ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଇଛି ଆପଣଙ୍କର criminal appeal referred by the same appellant disposed of on 17th କାହିଁ ଥିଲା
Same application that I filed.
Appellant has filed.
Response.
Appellant kindly see the last one. Appellant has filed preferred one criminal as well as one jail criminal appeal.
अच्छा नहीं से criminal appeal टा merit रे dispose of ହେଇନି ତ
ନା
Mr. kindly see order dated
ଭିଡିଓ କନଫରେନ୍ସ ରେ ଆପଣ ପଚାରିକି ସେଟାକୁ ଡ୍ରପ୍ କରିଦେଲେ ଏଇଟା
ଓହୋ ଆଚ୍ଛା ମାନେ merit ରେ ଦେନ୍
ନା
order dated କେତେବେଳେ କହୁଥିଲେ ମ୍ୟାଡାମ
17/3/2025 order number 48
in view of the order dated so and so अच्छा so and so okay engage okay disengage okay alright मैं CRL order टा भी रखिया କଥା ନା କୁଆଡେ ଗଲା ସେ order ଯେ ସେଟା ଜଣା ପଡୁନି ନା
CRL
ନାଇଁ ନାଇଁ 1312 dispose of ହେଇଗଲା ପୁରା କାରଣ ତା ଦେହରେ ବୋଧେ ମୋର ମନେ ପଡୁଛି ଯା ଲିମିଟେସନ ଦେଖେଇଥିଲେ ଗୁଡାଏ ହଁ ସେଇଥିପାଇଁ ଆମେ ତାଙ୍କୁ ଡକେଇଲୁ କହିଲୁ ଯେ ସେଟାରେ ଏଟା ଅଲରେଡି ତ ଗୋଟେ ଅଛି ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ତମେ ପୁଣି ଗୋଟେ କ୍ରିମିନାଲ ଅପିଲ କାହିଁକି ଫାଇଲ କଲ ଆଉ ବର୍ତ୍ତମାନ ଡିଲେ ରହୁଥିଲା 3 ବର୍ଷ କେତେ ଡିଲେ ଥିଲା ତା ଦେହରେ ସେ ଏଇ ଅର୍ଡର ଟାକୁ ଦେଖି ବାହାର କଲେ CRL ନମ୍ବର 1312 of 25 এটা କନେକ୍ଟେଡ ଏଟା ରଖିବା କଥା ସେଟା କେମିତି ରଖିନାହାନ୍ତି 1312/24
The order dated is 18/3/2025. May I read it?
17/3/25.
73/25 is the order passed in.
हाँ नहीं क्रिमिनल अपील नाम क्रिमिनल अपील टा जोटा डिस्पोज ऑफ होई छी तार कॉपी टे बाहर करो
on 73/25 this matter taken out for having order pursuant to the order dated 11/3/2025 the appellant Vichitra Benia appeared to virtual mode from jail and submitted that it in JCRL 2/22 Mr. Gautam Kumar Rao he has appeared in serial number 1312/24 challenging the same impugned judgment and order of conviction passed by the additional session judge Kontabanji in session case number 6/2018. He engaged as a advocate on his behalf. He has no objection.
In view of such submission, if criminal appeal is disposed.
Now what do you want?
Sir, we are receiving the fee nama.
Director last
Oh, acha. Let the land the land council as per the order fill up the land council for the state has produced the Wakalatnama signed by the appellant Vichitra Benia. Let the land council Mr. Gautam Kumar Rao they can say fill up fill up the Wakalatnama and file the same is taken on the top. हाँ फाइल कर लेगी हाँ कोर्ट भी फाइल करें ना कौन यस देख ले आपसे भी पड़े बिल पिटीशन कोर्ट ये कर लेंगे हाँ जो कौन सा था से जो वेलफेयर से जेल पर लगे होता ये दो हुई Yes, next.
Item 13.
File for bail file for bail I remember 271 Have you shot with copy on the learnings? Deposition copy there, sir. Just one. Deposition copy. Of the other. IN number 271 of 2025 is an application for bail. The counsel for the appellant supplied the deposition copy of the witnesses to the land council for the state in court today. To seek some time to go through this and release this matter next week as soon. Yes.
Item 14.
Mr. Mahathi, you will come next week.
Yes,
Copy दीजिए. Yes, Mr. Mahathi.
Yes, sir.
Have you received
that copy or something? That
bail application or stay realization of copy?
Detail.
You copy. IN number so and so, this is an application for bail, and IN number 1 of 2025, this is an application for stay of relation of fine. Let the copies of the interim application be served on the Land Council for the state by tomorrow.
Just now, I am sir.
During course of the day let them. अच्छा ट्रायल कोर्ट रेकॉर्ड अच्छी डिपोजिशन कॉपीज आपण जदि नथिबो ट्रायल कोर्ट रे आपण पेन ड्राइव रे कलेक्ट करने ऑर्डर पास कर दोछ आगे लेट द लैंड काउंसिल फॉर द स्टेट बी परमिटेड टू टेक द deposition copy of the witnesses examined in the trial court he is bent by the registry shall permit empty copy yes next week also also to the copy to the land amicus curiae kole तो आजी मैटर अच्छे आजी नहीं जीवे पेन ड्राइव रे नले पुनी डेरी डे इकले पाइबे तो जाहाले पेन ड्राइव रे जण कर नहीं जातो से आपन को दे दो है
Item 15.
bail application copy
Yes, yes.
The appellant is convicted under 3.
this year year she paper book अच्छी
Well,
कौन
302 IPC and he is in custody since 19/12/2019. He was not on bail. The prosecution is
come to paragraph number 2.
The unfolded prosecution story is that the deceased, who belonged to village Sisifani, was a married person having his wife and children, and at the relevant time of occurrence was working as a watchman at High Court of Orissa. He developed intimacy with the accused when she was 12 years old. The accused was placed with a son through the deceased. Though the accused was not the legally married wife of the deceased, yet they were residing in the rented house belonging to Umesh Chandra Seth at village Guripada. The deceased and accused were staying in the ground floor of the house, and one Chotrai Tutu was staying with his wife in the first floor of the said house. In the course of time, dispute at this section arose between the duo as the deceased did not give the accused status of his wife, and day by day their relation started waning. On 17/12/2019, the deceased came to his rented house to take his dinner but did not return to his village to his duty, for which his colleague tried to do PW11 tried to contact him over phone at about 12:30 a.m., to which the deceased replied that he will join him at 4:30 a.m. Thereafter, the deceased took his dinner and slept. While he was sleeping, the accused assaulted him brutally by means of big hook and committed his murder. At about 4:30 a.m., said Chotrai Tudu again tried to contact the deceased over phone, but this time the deceased did not receive the call. Said Chotrai Tudu contacted his wife, namely Malati Tudu, PW7, and asked her to go to the deceased room to find out as to why he was not picking up his phone. On his instruction, PW7 went to the house of the deceased and found chappal and bloodstain mark thereon. She immediately informed this fact to her husband, PW11, who in turn informed the matter to the deputy manager, housekeeping, and other staff. Then they all went to the spot house and called the deceased, but he did not respond to their call. The deceased was lying in a pool of blood with an injury on his neck, and a big hook stained with blood was also lying there. Then the housekeeping manager informed the matter to the police, municipality staff, and press reporter. Abraham, who was staying with the deceased, was found absent from the house. The accused, after committing the alleged murder of the deceased left Balesore and went to Baripada in a train. There she surrendered before Sadar police and confessed about murder of the deceased, explaining the reason of his murder.
So the case is based on circumstantial evidence.
Circumstances evidence.
You are the wife.
Your Lordship.
So you are the only person present in the house, and your wife, your husband, was killed and the homicidal death.
Your Lordship.
And what is your explanation how your husband died?
Here, two facts which was not dealt by the learned trial court. One, the status of the wife was not proved, so that
Let us say it has not been proved. You are not the legally married wife, but the evidence has come that both of you were staying together in that house in question, where the dead body was found. The deceased had come to the house, and you were present in that house, and the deceased, after few hours, the dead body was found, and the doctor must have conducting the postmortem. He has opined that it's a homicidal death, and you are found missing from that house, and you surrendered in the police station. So, in the accused statement, what is your case? How your husband died, a homicidal death, or let us say it is not the husband legally married, but you are staying with them. So, let us say you are having live-in relationship with that man. So, what is your explanation?
Your Lordship, may kindly say it has been stated by prosecution that the accused was 12 years old when they were having relationship. The deceased and the accused, Your Lordship. Thereafter, through 313 statement, I came to know in 2020 the accused was 25 years. Your Lordship. What I want to point out before Your Lordship, two things. The wife of the deceased was never examined whether there was any relation with the accused. That was not proved.
Whether the witnesses have not stated that you were staying with the deceased in the same house for a number of years, and on that day also you were with the apparent with the deceased in that house.
Yes, it has been stated by PW7 and PW11. Here, what I want to point out, Your Lordship, that PW6, who's the elder brother of the deceased, he also states that I don't know who was staying with the deceased. So here, what is important, Your Lordship, whether the accused was staying with the deceased, it is only the statement of those PW7 and PW11, but not it was never stated by the family member of the deceased. And as per the prosecution, it was a long relationship. How the family member of the deceased were not aware about this relation, and she is also blessed with a child, a male child.
I've disputed that I was not residing with the deceased. Rather, your case, as it appears from question number 33, so Marandi mote agu rakhitila so and so o achi tapare au gote question answer deichanti. या ना कोन जे डिसीज होला
बंध मारंडी.
Question number 60.
36 madam.
Question number 60 होची हम बड़ा मरांडी ओरसुरु गर्भवती होइतली. 36.
Transfer from the evidence that he was staying in the first floor and deceased was staying on the ground floor on monthly rent in the house of Mukunda Seth. What do you say? ମୁଁ ରହିନି କି କହିପାରିବିନି ଏଠି.
ରହିନି କି କହିପାରିବିନି କଣ?
PW11 who says that कि ମୁଁ phone कली, he never says कि ମୁଁ phone कला बेला I felt the presence of Sita, the presence of the accused He never, only after the
ନାଇଁ
death.
ସିଏ ତ ଫୋନ କଲା, ସିଏ କଣ ଘରେ ପାଖରେ ଫୋନ କରୁଥିଲା ନା ସେଠି ଥିଲା? ସିଏ ଗୋଟେ ଜାଗାରୁ ଫୋନ କରିଛି, ସିଏ ଡିସିଷ୍ଟ କୁ ଫୋନ କରୁଛି।
ଆଜ୍ଞା
ସେ ଡିସିଷ୍ଟ କହିଲା ମୁଁ ଆଉ କିଛି ସମୟ ପରେ ଯିବି।
ଆଜ୍ଞା
ଯୋଉମାନେ ସେ ଏରିଆରେ ଥିଲେ ସେମାନେ ହିଁ କହୁଛନ୍ତି କିଏ ସେ ଦିଟା ୱିଟନେସ କିଏ ପିଡବ୍ଲ୍ୟୁ
7 and 11.
7 and 11 ତ ସେ ପିଡବ୍ଲ୍ୟୁ 7 and 11 ଟି ବାହାର କଲ।
7.
ସାତ ନମ୍ବର ସାକ୍ଷୀ ହଉଛି କଣ?
Malati Tudu.
Malati Tudu. I know the accused, I know the deceased କହିଲା। Deceased and accused were staying in a rented house at Guriapada. I was staying in the first floor of the building and they were staying in the ground floor. I and accused very often talk with each other. The accused informed me that she is not the legally married wife of the deceased and staying with him as kept. The accused and the deceased were known each other when the accused was 12 years old. Since they were in physical relationship and out of that the accused was pregnant at the age of 12 years, she terminated the pregnancy. Further, accused after the incident, the deceased used to keep physical relationship with her. And she gave birth to a son. My husband and the deceased ones were together. Before the date of occurrence, told me today that I have a night duty with the deceased. And then he went to his duty. In the early morning, my husband telephoned me informing that the deceased had gone to his room to take meal at night. He could not keep out his phone up. Thereafter, my husband asked me to check the deceased in his room. Then I went to his house, knocked the door, and I found a pair of people outside the door and saw blood spatter present. Immediately I informed this fact to my husband. Then my husband, along with his in their presence, I opened the door and seeing the room. Came back, my husband and son.
PW5 also says.
No.
She also stated that she had no good relationship with the accused.
The deceased and the accused were staying there for 2 months. That is also the PW5.
4 also.
So number of witnesses are stated.
PW5 is clear.
Other circumstances are also there.
This is one about the
P2, 2, 7 and 11. They have stated that the accused and deceased, they both were staying together in that house, the spot occurrence. That apart, P2, 2, 7 and 11.
And 5 also.
11, 5 position.
4 also.
ସେମାନେ ରହୁଥିଲେ
staying together.
PW11 stated that on the relevant date at about 10:45 p.m. the accused taken the motorcycle of the PW11 and went to his house to take his dinner. Thereafter at 12:30 PW11 over phone contact with the deceased. Deceased stated him that I will return at 4:45. Thereafter, when the accused the deceased did not return, again the PW11 called the deceased, no response. Thereafter, PW11 over phone intimated his wife.
That is PW7.
When the PW7 went to the house, found that. Then, my lord, second circumstance, my lord. On the next date, the accused went to Baripada Sadar police station and confessed that she has committed murder before PW 20 and 21. Police sub-inspector and one constable. That fact was entered into station diary entry. That is exhibit 15.
No, but main thing is that
my lord, from the trace of the accused.
No, first of all, staying together. dead body was found from the very same house.
Same house.
Right. Absconding of the accused from the house. He was not seen.
Not seen.
Then he surrendered, as you said.
Exhibit 15 is the stationary entry at Sadar Police Station, Baripada. From the dress of the deceased, the police officer, they found some blood stain. That was sent for chemical examination. Exhibit C report is at page 77. Exhibit.
Accused dress ru mane ta sari ru
blood stain detected.
Human blood.
Human blood. Grouping not detected. It is deteriorated. Exhibit 25.
What is the explanation given?
Explanation is, my lord, question number 130, question number 109.
My
lord.
ମୁଁ ଜାଣିନି ସେ ଯୋଉ ଛୁଆଟା ଥିଲା କୋଡା ତାର ଗୋଟେ ଛୁଆ ହେଇଥିଲା ଲେଖୁଛି
ଛୁଆ ତ ସେ ଘରେ ତ ଛୁଆ ଯେତିକି ଏଭିଡେନ୍ସ ଦେଖିଲି ସେ ଘରେ ସେ ଛୁଆ ରହୁଥିଲା ବୋଲି କି କିଛି
ସେ ଯୋଉ କହୁନି ସେ
ସେକେଣ୍ଡ ଆଉ ଗୋଟେ ପ୍ରଥମେ ଗୋଟେ ଟର୍ମିନେଟ ହେଇଥିଲା
ସେକେଣ୍ଡ ଆଉ ଗୋଟେ ପୁଅଟା ହେଲା
ଜନ୍ମ ହେଇଥିଲା ତାଙ୍କର ସେ କିଛି ଖର୍ଚ୍ଚ କିଛି ବିୟର କରିନଥିଲା ଘର ଭଡା ମଧ୍ୟ ଦଉନଥିଲା ଛୁଆ ବିଷୟରେ କିଛି ନାହିଁ କୋଉଠି ଅଛି
ନାହିଁ PW7 ର ଯୋଉ ଏଭିଡେନ୍ସ ପଡିଲେ further the accused told me that after the incident the deceased used to keep relationship with her. She gave birth to a son.
ସେ ପିଲାଟା କୋଉଠି ଅଛି
ଇନଫର୍ମେସନ ବହୁତ ଗୁଡାକ ଛୋଟ ଛୋଟ ଛୁଆ ଗୁଡାକ ତାଙ୍କ ମା ମାନଙ୍କ ପାଖରେ ଜେଲରେ ରହିଛନ୍ତି ଆମେ ଯେତେବେଳେ ଜେଲ ଭିଜିଟ କରୁଛୁ ଦେଖୁଛୁ ତେଣୁ ସେମାନଙ୍କର ମାନେ ପାଠ ପଢା ସେ ଅଙ୍ଗନବାଡି ସେଣ୍ଟରକୁ ନଉଛନ୍ତି ନ ନଉଛନ୍ତି ସେ ବହୁତ ନେଗ୍ଲେକ୍ଟ ହଉଛନ୍ତି ତାପରେ ସେମାନେ ଛାଡିକିନି ମାକୁ ରହିପାରିବେ
ବାଳାଶ୍ରମ ନେଇ ରଖିଲେ ହେଇପାରିବ
ନାଇଁ ଷ୍ଟେପ୍ସ ପ୍ରାକ୍ଟିକାଲ ଡିଫିକଲ୍ଟି ହଉଛି ଛୁଆ ଗୁଡାକ ମାନେ 3-4 ବର୍ଷର ଛୁଆ
in extrajudicial confession also.
Extrajudicial confession is before executive magistrate.
PW 15.
27.
PW 15.
PW 15.
PW 15 is the counsel.
Accused confessed guilt in my presence. He stated that the deceased is not giving me name and identity to our child.
Leading to this one,
which I killed the deceased in the anger by means of guilt. Second part.
Leading to discovery matter.
Because it was during recording of the confessional statement, she stated that PW, he witnessed a PW 15 that besides myself, the IO was present, magistrate present, leading to discovery.
Leading to discovery.
First he says Koturi, she played away with the Koturi. Subsequently, in the cross-examination, he stated that PW 15, the Koturi was lying there.
Koturiଟା ଆପଣଙ୍କ ଇନଷ୍ଟାନ୍ସରେ ମିଳିଛି?
No, it was lying near the dead body.
Leading to discovery. So,
and brother of the accused, accused is PW 18. He stated
15 by the way. 15 is
owner of the house.
So, now Mr. Nayak, two things is there. That one, she's a lady. She's in custody for more than 5 years. Because judgment the Kuchi second page accused details that she was a UPP from 1912-2009. Obviously 5 ବର୍ଷ ହେଇଗଲାଣି ବାକି ସେ ଛୋଟ ଛୁଆଟା କଥା ଟିକେ instruction karan in view of the evidence that whether the child is staying with her or she died
whereabouts of the child,
the status of the child seta hala o jail lai achi मैडम को जेल अच्छी वकालतनामा साइन करछन्ती बारिपदा अछि
It was engaged by this honorable court.
बारिपदा अछि वकालतनामा जणा पड़छ अच्छा
Appraisal Baripata.
लिखि दंतु IA number to answer this is an application for bail Mrs. Sunita Biswal and counsel appearing for the appellant submitted that the appellant is in judicial custody for more than 5 years. The appellant who is a lady is in judicial custody for more than 5 years, which would be evident from the judgment itself. Further submit that the case is based on circumstantial evidence and evidence of the trial court of PW7. It appears that she was staying with the deceased and there was physical relationship between them, between the appellant and the deceased, for which she gave birth to a son, to a male child. Let the land and counsel for the state obtain instruction about the status of the male child. Allah, put up this matter. Next week as to the
Item 16.
Chapter 35 दिन on life imprisonment.
Yes. 02 along with 5 and 10 kilometers.
Condemn कर दूंगा life imprisonment. IA number 1 it is an application for condemnation of delay. The stamp reporter has pointed out that there is delay of 735 days in filing the criminal appeal after hearing the land and counsel for the respective parties, going through the amendments taken in the interim application. And since the appellant has been sentenced to imprisonment for life, we are inclined to condone the delay in filing the criminal appeal. Accordingly, delay is condoned. IA is disposed of. Hard admit call for the trial court report, interim applications for bail and stabilization of fine considered after receipt of the trial court report. The deposition copies of the witnesses is supplied to the land counsel for the state by the next day. Yeah. Obviously.
Item 17.
On behalf of Mrs. Patnaik, I pray for an adjournment, my lord. Not to be taken.
Reporter on আসছে reporter class E. Released by the final. So, madam, it's a jail criminal appeal of the year 2008. Don't ask for time.
Patnaik is not well.
No, you see,
Whereabouts of the appellate?
leave it. He has been released on bail And if the result of the appeal so desires, then he will either surrender. All appropriate coercive steps shall be taken by the trial court. That is not a ground defer the hearing of the jail criminal appeal.
So last occasion, Ms. Patnaik was here. She's not well today. Let this matter be taken.
But why have you not prepared? You could have prepared.
Not wrong. The qualified jail criminal life decision. ଆପଣ କେତେ ବର୍ଷ ପ୍ରାକ୍ଟିସ ହେଲା?
One. 1.5 years. 1.5 years.
ନାଇଁ ସେ କଥା
10 years minimum.
ହଉ କାଲିକି ରହିବ. You are the daughter of what is your name?
Shreya Patnaik.
Shreya Patnaik. So your mother will be all right by tomorrow.
Next week.
You must be taking her care properly. So she will be all right. We also expect her to get well soon. So we are taking up next week. Okay. Miss Shreya Patnaik, Land Council, appearing for Mrs. Shashwat Patnaik. Praise for an adjournment on the ground of element of the Land Council. This matter next week. Yes, for hearing. Yes.
Item 18.
Is now.
कौन है जी? नहीं ना जेल से देखिए बेल ले जाइए बस. This is item number 17. Kuda. Oh, अच्छा आसिलानी को मैटर.
Item number कितना?
कितना? 10. अच्छा. हाँ काउंसिल अच्छा नहीं है. हाँ से तांकर शॉर्ट ने निक नेम टा देइथला. जस्ट जॉइन कले कहिबे काई आसिना तो. को जेल अछि से? नहीं ठीक अच्छी से जॉइन कले हम कहिबे. हाँ हमें अन्य मैटर टेक अप करछि तो.
Item 18.
Item 21 I am ready.
ठीक है रोंदो. Report received from IIC so regarding present here so the flag expired study देखना. हाँ ये तो बंची जी अच्छी तो सेट. तो इटा करा. आपण आउट मैटर रे रेडी अछंदी. केत नंबर 21. अच्छा आसुची तापर. तापर नेक्स्ट आइटम ता एकदम आइटम नंबर 19. Report मेरा बेल ले पड़ी थी. Order dated 3/6/2012. Item number 19. So, madam, you are ready?
Yes, Your Lordship.
What is the offense here?
302, Your Lordship. 302, 460, 394 of Indian Penal. Let's get that.
How many appellants are there?
Here, Your Lordship, 2 appellants are there. Another is adjudicated who has been convicted.
Your body. Paper will be. आरंभ कर देथिबा काली नंबर
I think it's
कौन
10 वर्ष बोधे practice ହେଇନି।
ओहो
अच्छा
आपण शताब्दी सामुदाय तो ये जेल क्रिमिनल अपील आपण को एंगेज कराई छी ठीक है वो ऑर्डर एंगेज कराई छी आपण को
Para law user copies.
So admittedly you are not having practice of 10 years.
Name of my senior ने kindly.
Yeah.
You can assist.
You can assist. Since though by order dated 12/9/2024, Ms. Shatabdi Samantray is engaged to argue the appeal on behalf of the appellants, but has been awarded to the appellants, and Ms. Samantray is not having the practice of 10 years in view of the decision of the Honorable Supreme Court in the case of Honorable Lal versus Swans, reference judge. She is disengaged, and Mr. Vishwajit Mahanti, sorry, Vishwajit Naik, he is engaged as amicus curiae for the appellants. Acha. In disengaged award
in addition
to Mr. Vishwajit Naik is engaged as amicus curiae, and Miss Shatabdi Samantray shall assist him in the argument. So, engage वाला हमने ताकि ये कौन की जानी मुझे ये will be paper with Mr. Naik
and
brief for briefing, and the matter will be taken up next week.
Yes,
And the name of Mr. Vishwajit Naik will be posted in the cause list and
I can tell the police list.
Item 10.
अच्छा ये कासिया उर्फ सिद्धांत पलेई आपण हमको सुनी पारुचंती अरे से ये अनम्यूट कर हमको अनम्यूट करिया
अनम्यूट करंतु अनम्यूट
सर अनम्यूट करंतु
कंप्यूटर की अच्छी है
आपण हमको सुनी पारुचंती
नहीं से सुनी पारुचंती फायदा अनम्यूट करो कासिया उर्फ सिद्धांत पलेई
सुनी पारुचंती आपण
କରିଚନ୍ତି କ୍ଲିୟର ଅଛି ପିକ୍ଚର କ୍ଲିୟର ଅଛି
ଆପଣ ଶୁଣି ପାରୁଛନ୍ତି ଆମକୁ?
ଏବେ ଜଣା କଟି ଯାଇଛି।
ପୁଣି ସେଟା
ଅନମ୍ୟୁଟ କରନ୍ତୁ, ଅନମ୍ୟୁଟ କରନ୍ତୁ।
ଫୋନରେ କୁହ
ଆପଣ ଶୁଣି ପାରୁଛନ୍ତି ଆମକୁ?
ପୁଣି କଟି ଯାଇଛି।
ଶୁଣି ପାରୁନାହାନ୍ତି? ଶୁଣି
जो आपन को आजीवन जो कारादंड हेची जो ऑनगोल्ड सेशन जज कोर्ट रे आपण एठी जो अपील टा हाई कोर्ट रे दाखल करचंती ता देहरु तो अन्य वकील जरिया रे जुगल किशोर पंडा एवं तांकर जरिया रे फाइल करथिले तो गोटे वर्तमान आपण गोटे दरखास्त देइचंती से दरखास्त रे लिखा हेची जे दरखास्त टा होची 25/2024 रो ता देरे लिखिचंती वर्तमान मु वकील श्रीमती सुनीता दास को मामला परिचालना करिया पई चाहूची एटा आपण लिखि देइथिले
आज्ञा
कोन पटरे
आज्ञा
अच्छा वर्तमान वकालत नामाटा जो फाइल हेची जदियो ता देरे दस्तखत आपणकर अछि किंतु एडवोकेट होचंती प्रणयिनी दास महापात्र सी वकालत नामाटा फाइल करचंती आपणक देखि पारथिबे सामना रे छिडा आइछंती आपण तांकु ही एंगेज करिया चाहूचंती तो
आज्ञा
कारण नाटा अलगा अलगा हे गेला त आपण लिखचंती सुनीता दास आउ वकालतनामा फाइल हेची प्रणयिनी दास महापात्र बेली सेपई आपण को डाकिवार उद्देश्य ला आसिया यदि आपण हां कहबे ताले आमे मैडम को आपनकर वकील हिसाब रे नियुक्ति दबु ठीक अछि
आज्ञा
तो
आज्ञा ठीक अछि
हो ठीक है हो ठीक अछि ये ऐसे जो आपण से जो ए जेल रो जो ऑफिसर अछंती आपण ना कोन
मनोज कुमार खुंटिया सर
केते वर्ष लानी चाकरी लानी
चाकरी सर हेलानी 29 वर्ष
ना केते
30 वर्ष सर
30 वर्ष ला कोर्ट सामने रे जते छिडा आइतले ते पछ पटु कोन हाथ धरी छिडा आइतले कोर्ट सामने रे जते छिडा होंती सेते बेले केमती छिडा होंती सेटा शिखाइनी आपनकर
सर सर भूल है जे आउ सर हबनी सर
देखो the appellant Garcia alias Siddhant Pole appears to virtual jail from Kuntuni jail. Era Kuntuni sub jail na jail?
सर मॉडल कॉन्वेंट प्रिजन एमसीपी जेल सर
अच्छा मॉडल कन्विक्ट्स प्रिजन Kuntuni. He submits that he has sent the prisoner's petition, which is at flag B, for engagement of Mrs. Sunita Das and Pranayini Das Mahapatra, who has filed the Wakalatnama, is the same Sunita Das, and therefore the Wakalatnama be accepted. The Wakalatnama filed by Mrs. Pranayini Das Mahapatra and her associates are accepted. The names of other counsel shall not be reflected in the cause list henceforth. Stop. कौन पे interim bail file कर देंगे?
Interim bail as the petition of mother is in and nobody is taking care to.
ଆପଣ କଣ ହେଇଛି ମାଙ୍କର ଯୋଉ ଦରଖାସ୍ତ ଦେଇଛନ୍ତି?
ମାଙ୍କ ଦେହ ଖରାପ ଅଛି।
କଣ ଦେହ ଖରାପ ଅଛି?
ହାର୍ଟ ର ପ୍ରୋବ୍ଲେମ ଅଛି।
ବଡ଼ ପେଟ
इसको ये नहीं मेडिकल डॉक्यूमेंट नहीं
मेडिकल मेमो करी दाखल करके
allow some time to
25
you have obtained it now.
25 रे दाखल मेमो करी दाखल
All right. IA number so and so this is an application for interim bail. Land Council for the state seeks some more time to obtain instruction on the interim of the bail application. So also the medical prescription which has been filed with a memo dated 25 to 2025 of this matter next week. In the meantime, the Land Council for the state shall obtain necessary instruction. आपण जो दरखास्त देइचंती जो मांकर देह खराब बेली जो अंतरीण जामीन पाई सरकारी वकील ता धीरे किसी समय मागिचंती जे ता ऊपर नेबे आपनकर मांकर देह कोन खराब हेची कि नाही आ जो प्रेस्क्रिप्शन ता देइचंती ता नेबे तेणु आसंता सप्ताह को आपनकर से जो जामीन ऊपर सुनानी पाई धार्य रहिला तारीख हला
आज्ञा
काली आपनकर नबा पिकअप करियो
Item 21, 18 टा next week हो item 21.
नहीं लिस्ट थाउ विल टेक अप दिस पार्ट कोन से अर्जन करियो ने पुराना मैटर उडा
ना मु से
चलो ठीक है
I am ready in 21.